I mean, I did okay, but I'm just seeing that. I was supposed to not have school for 2 months. Like, I anticipated like 3 hours or not, like when I'm going to work. So I was like, man, we were like, let's start to go through. And I was like, yeah, if we can make it happen. Going on the knees, like, trying to do shit. No. 3 days ago, he called me. So I need you to make a decision right now. You want to know grad school? Yeah. So like the first time I like really like the final like decision. And this class and this class I came from. And I tried to maybe take days in this class.
I did. Do it. I
I was in that video production. Oh, no, you were. Yeah. I know. But now they took me out. And they like basically booted me. I walked in one day and like all my shit was getting moved out. And they were like, yeah, you're not at this office anymore. I was like, okay. Well, I might just have an office. So like, I'm not just doing grad school. A lot of things are I got a bad school.
I guess so.
That's my cousin actually on the way. Good eyes, good eyes. No, because I did like RTC at all high school.
Everybody got one of these?
I guess I'm smart enough to do that.
Anybody come in the door?
A lot of my friends went, I mean, like fresh out of high school, that was kind of my plan. And like now, like I'm just like 4 years out of high school, you know what I mean? You start talking to people, yeah, when you start talking to people, and my friends, and like, I don't know, man, like all my friends are just like mad different. You know, it's really, yeah, not like changing, like just like the idea of changing, like more just like the shit you guys see. Like not like, oh, it's more just, okay, like yeah, that's like the change. But yeah, like I'm mental.
Hello, everybody.
Yeah.
Welcome.
I'm just like, yeah,
I'm David Weissman, and we're going to have some fun for the next 8 weeks. I'm relatively informal. I want to try and make this experience for you guys, not for me. And so, in keeping with that, while I'm going to be doing most of the talking, because that's what I'm here for, I want this to be as interactive as possible. Because the best, in my experience, the best education experience that you have is when you're interacting, you're not just sitting there listening to somebody drone on. That means questions, that means if you have a point of information you want to try and add to the extent that you can, or if you want to lead the discussion in a different direction, I'm here for you. That's my attitude. So, what I just gave you is a commercial real estate contract. This is a form that is produced by the Florida Association of Realtors and is used informally for commercial contracts. That's not to say that it is a mandated form, but it's a good way to get an idea how a real estate transaction works. Basically, this is the constitution that governs a transaction from start to finish. It is the lead document that everybody goes back to when they're doing any kind of transactional work. So I figured this is a great way to get into the different aspects of a real estate transaction, to kind of give you a feel for what the things mean, and we'll see how it works. And as we go through the course, I'm going to try and use different documents to introduce different, just to do it the same way, to try and be as practical as possible. And I guess the best way for me to do it test is to put this out somewhere for people that are coming, person coming in late. Sorry, not picking on anybody.
No worries.
But I'm marking it down, no. So just, I guess, a little bit of like, who is this guy? I'm a practicing lawyer, been practicing real estate law for almost 40 years. I've done a lot of continuing legal education, lecturing. I'm board certified in real estate, and I've served on the Florida Bar's Real Estate Certification Committee, which means I know how to write a really nasty test question. But I won't do that. My test questions will be, I don't want to scare anybody. But I have done teaching in the past, so I'm not just here as a practitioner trying to play at this. Again, though, over the course of my career, the best educational experience I have ever had is one that I go to every year in Washington, and it's an advanced commercial leasing institute that Georgetown University Law School sponsors, where they give you a topic and then put you into groups, and you discuss amongst yourselves as practitioners, and then for the second half of each session, you get up and you talk around the room with different ideas. I'm not going to quite break out into that kind of a thing because that's a little too complicated. I'm not that organized for that. But then you go to a different session, so you'll be working with different people. The point is to make it interactive and to make it so that we all share ideas a little bit. So with that said, and again, questions available. We'll worry about contact information. I'm trying to sort my way through the Nova email. I'll figure that out. So let's get started. So who thinks this is a contract?
It says contract.
It does say that, doesn't it? Does that mean it's a contract? Okay, so it's a form. So really, you need a few things to make a contract. And the two most important things are offer and acceptance. And I'm going to go back and forth between being really technical legal and being practical with this. We'll get a feel for it if I'm going in the wrong directions, or you feel that if you're not understanding something in a direction I'm going, please somebody say something. Like I said, I'm here for you guys. Okay, so it's a piece of paper, and what happens in the very beginning of the process is somebody who wants to initiate a transaction, it's usually the buyer, has this filled out. Either they'll fill it out themselves or they'll have a lawyer or real estate agent fill it out for them, and they will submit it to the owner of the property, and it's got all the terms and conditions upon which the person presenting it is willing to acquire the property. But until the other party accepts it, it's not a contract, it's just a piece of paper. Now, there's a few different things, basically three things that the seller, upon receiving this from the buyer, can do. They can accept it, sign it as it is, in which case it becomes a contract. They can reject it. They just say no one's obligated to accept anything. Or they can change it and give it back with different terms. That is called a counteroffer. A counteroffer is technically a rejection of the original offer, and the original person who presents the offer, the buyer for simplicity, doesn't have to respond to the counteroffer, and the deal is dead. Very often, most of the time, what happens is it goes back and forth several times until the parties agree on the terms. That's when it becomes a contract. So let's take a look at some of the things that make up the contract, and hopefully by going through this document, you'll get a feel for how a transaction works. Because the things that appear to be very simply printed on something like this, and all these blanks, can have tremendous meaning in how the transaction goes. As simple as the first two lines, which are the parties, the buyer and the seller. Who's the buyer? Well, almost 3/4 of the time, you're going to see somebody write a name with words like and or assigns. And the main reason for that is the person making the offer doesn't quite know at the outset of the transaction how they're going to acquire title. So it's important for, depending on the kind of transaction, as a seller or as a person reviewing the contract for the parties, that whoever is signing the contract has some responsibility. Because as you'll see as we go through this, you have responsibilities under the agreement that have to be fulfilled, and you don't want a non-entity somebody that doesn't legally exist, like, oh, I'm going to form a corporation to create this, but I haven't done it yet. So I'm just going to use the name I'm thinking of using to put on the contract form. Very common thing that's done, but there's no contracting party. There is no buyer. It doesn't exist. So when you're looking at something like this, regardless of whether you're doing it technically from what I do or if you're involved in a real estate transaction and you see that, you kind of want to find out, does this buyer exist? I'm talking about entities primarily. In today's world, it is so easy. You just jump on any computer, tablet, whatever, and go to the Florida Secretary of State, and you can find out if the entity has been formed. If it has not been formed, if it doesn't exist, then you want to go back and say, hey, I want somebody with responsibility. You'll see that there are things that that buyer, once they acquire the rights under the contract, can do to the property that can cause a problem that you want to avoid, and you want to have somebody responsible. On the other hand, from the buyer's perspective, by having the right to assign the contract, the buyer has flexibility to create an entity down the road. For tax purposes, liability purposes, they have partners, whatever the reasoning is, they want to be able to move the rights of the contract into some other entity that they're going to create or another entity that they have created. Now, in the development world, obviously, people have many different entities for different reasons. Usually single-purpose entities exist. We'll get into entities later on in the course, but a single-purpose entity is formed just for that purpose. That'll get transferred into that entity later, but they don't want to go to the expense of creating an entity specifically just to make an offer that may not get accepted, so people will use an existing entity and have the right to assign it. The next line, that's just the first line. The next line is the seller. So that seems fairly straightforward as well, but you want to know who owns the property. I mean, if you're going to get somebody that's going to sign a contract and say, hey, I agree that I'm going to sell you this property. So now the buyer's going to go and start spending money. They're going to do title searches and lien searches and have the physical parts of the property inspected. They want to know that once they've completed all these tasks and they've spent all this money, that they have someone against whom they can enforce the contract and get the property. Again, computers make it so easy. Just a simple trip to the property appraiser's website will give you a cursory view of who the owners are. Now, if it's a single entity, it's usually not a problem. The problems come up with, and I'll delve into residential too, although it's a commercial contract, husband and wife may own the property together. And only the husband's in the room to, or only the wife is in the room to sign off and to agree to buy or sell. If you don't have both parties signing the agreement, or you don't have every owner in the case of multiple entity owners, you don't have an enforceable contract. You probably don't want to buy half the property. Worse yet, if it's husband and wife and they own it by the entireties, you have almost nothing because, as I'll get to again, I'm going to bounce back and forth on these things like entities. Husband and wife are considered to be one entity at the law together. So when they own as husband and wife, it's it's one legal person. So you have to have both signatures there. Buyer and seller, easy. Very, very rarely will you see the seller have the right to assign. There are a couple of instances. Sometimes I'm working with one client which is a real estate investment trust. They're highly regulated as to what they can do in terms of what they can own, what they can sell, where they can have a profit. And after they've entered into agreements to sell the property, sometimes they have to move the sale into a different entity to preserve their tax benefits. That's unusual. The other thing, which we'll talk about much later on, is if you need to assign it to a qualified intermediary for a tax-deferred exchange. I don't want to get into that yet. Street address. Next line. I'm going to go through this in as much detail and give you some ramifications. Street address is really easy, except that it's dirt. A lot of times, if you're buying vacant land, the post office hasn't given the property a street address. The street address is really not a good qualifying legal way to describe a piece of property. It's used all the time for convenience. In residential, obviously, you know you're buying 123 Main Street. Even if you're buying an office building, it has an address, but it doesn't legally describe the property. Example, office buildings have parking lots. They're not always on the same parcel of land. So I could enter into a contract to buy the office building at 3300 Nova Drive, And when I get there, and I get to the closing, if that's all I have, I'm gonna get a building, but at 3310 is the whole parking lot that is separately titled or separately described, and you have a useless office building. So street addresses there mostly for convenience. The legal description is probably the most important. The legal description is a legal way to describe the property. Unfortunately, I don't have the benefit of an overhead projector. I had brought a survey to show, but we'll do that. We're going to move. We're going to move to another room next week. More comfortable chairs. I'm sure you'll be happy about that, and a little more technology. That when I first came here and signed on to do this, I was shown all kinds of cool devices which aren't in this room. It's okay with me, but it was just I put a piece of paper under it and you get to see what I'm looking at. A survey is a drawing of the property by a surveyor, registered land surveyor, that depicts the property and the buildings on it and the other improvements on it as it relates to the land. So a legal description can be one of several things. In its simplest format, it could be Lot 3, Lot 12 of Happy Acres. That is according to a plat. A plat is a recorded map of a large piece of property. Take, for example, this classroom. If this classroom were a tract of developable land, and a builder was going to buy it and wanted to sell off each of the desks, the builder would record a map that would show graphically each desk with a number, and it could be desk 1, row 3, desk 2, row 3, except it's lock and block. And once that is recorded in the public records, you can always refer to that desk as desk 1, row 3. So that makes it easy. Another way to do it is called a meets and bounds description. A meets and bounds description is M-E-T-E-S. Again, by the way, the textbook is really more for background. I'll tell you things that will be helpful in the textbook, but less of what I'm doing is going to be like staring at the textbook. It's going to be more of the practical. You'll read about legal descriptions, and we'll talk more about legal descriptions, and I'll show you more about it. But technically, what a meets and bounds description is, it's a measured description of the property using courses and distances. So this classroom will be described as beginning at that door, come 100 feet, and whatever this direction is probably close to due west, thence 50 feet south, then 100 feet east, then 50 feet north back to the point of beginning, and that describes the box. But you have to get to the beginning point, and that's where it can get a little complicated. The beginning point can be, that could be a hallway that's described. And again, I'm using analogies of what we're sitting in physically versus what's out there in the land, but it's similar. That hallway could be described as a highway, for example. And so you could commence on a point located at the intersection of name of the highway and a cross street. And that corner, which is legally described, and there may be a marker there, is your starting point. Or, and this is, anybody live in Weston? Anybody know Weston well? So out in Weston, when they did all the commercial property out there, everything started at one point, and the descriptions were this long to get to an individual building. And it was a little torturous because if you weren't familiar with it, you'd basically be starting and going down this road and up that street and turn here until you got to the tract of land you were working with, and then the very buildings within the tract of land. So that's a little more complicated, and it results from not creating a more simplified way of describing it. So that's the legal description.
Did they do that? Is that a Canadian thing?
No. Why?
I mean, the whole thing was master planned by a Canadian company, right?
No. Not originally, no. Is that what, Equitable or Arvida? Of course, I'm talking about mostly the Department of Commerce. The residential areas were done with plats, with maps of the area. It was the commercial areas that they used what's called a perimeter plat, which would be like describing this whole room, and then to get to each individual desk, you do measurements and distances. And it's very cumbersome when it comes to lots and lots of properties, because instead of just being able to describe desk 1 and row 3, every single document has a description like this, and then what happens is people start typing the documents and retyping the documents, and you get mistakes. And when you get mistakes, the legal description is wrong, and it messes up the title, and it's a disaster for generations until somebody fixes it. Which brings me to the standard of a legal description. Legal description, what is defined as a legal description, and that is, okay, and that is whether or not a legal description is adequate is defined as whether or not a registered land surveyor can locate the property from the description provided. So, the reason for that is, let's take, there's a typo in a legal description that screws things up. So, let's go back to our box. And the box goes around 3 ways. Remember I said 100, just for argument's sake, 100, 150, 50. So there's a typo, and instead of that last call being 50 feet, the 0 gets dropped off. So it says 150, 105. Well, that's called it doesn't close. But if the sentence is there back to the point of beginning, that saves it. Because you know that from that point, it's telling you to go along that described line back to the point of beginning. So that saves the legal description.
I have a question on that.
Yes?
Isn't that point of beginning based on, I don't know if I have the name correct, a specified point in a city and everything goes out from there?
We will get to that later on. The answer is yes. That's further up the description, and because I don't have the graphics to show you, and I don't have, so I will get into legal descriptions in more detail and answer that very question. But yes, basically there's a line that, to go all the way up, there's a line that runs through Tallahassee. It's called the Tallahassee Meridian, and it's a grid system that's been placed all over the place, and it gets smaller and smaller and smaller. Township and range are the large things, and then you get into sections, which are the smaller measurements. There's 36 sections to a township.
Yeah.
So yes, so that would be the starting point. So you'd be in section 12, but to get down to something this small, you have to keep breaking it down further and further and further, and then once you get to the smallest measurement, you can't just keep saying a quarter of a quarter of a quarter of a quarter of a quarter unless it's a square. And it's done that way too. I mean, it's a little confusing, but if you have the right paperwork and you know what you're doing, you can find the real estate by chopping down the quarter sections. It's basically, you keep drawing squares. And I'll bring something and show you that. But when you get to an irregular shape, you can't do that anymore.
Okay.
That's where that happens. One of the things that is not on this form that I think you'll find on a residential contract that would be right in here around the legal description, and which most people will add into the contract here, is the tax folio. It's the county property appraiser's number that identifies the property in their records. It's helpful, it ties it up, it helps to describe the property, but it's not necessarily binding. And the county will tell you, or at least they used to, they're less difficult than they used to be, of a very good property appraiser, that they're not bound by the legal description that we're using. They're bound by what's on their maps. And that can cause a conflict from time to time. The property appraiser's folio number is the number that they used just to identify this property for tax bills, for assessments and things like that. Then there's, here on line 8, it says personal property. Personal property, as opposed to real property, personal property is anything movable. Every piece of equipment you're looking here, this is the desks, chairs, the podium, the computer, it's all personal property, anything movable, as opposed to real property, which is land, buildings, and sometimes fixtures. Fixtures are things that are permanently attached to the real property. Fixtures can be something like, well, I don't want to say the blackboard because they're a whiteboard, because although it's affixed, it can be removed and damage removed from it. But for example, the pipes, generators, yes?
So I've heard of foreclosed homes getting the cabinets ripped out because of maybe anger, but probably there's a dispute on the classification of a fixture or not. Is that something you've seen? 'Cause the cabinet
Worse.
Work.
Oh, much worse. Because,
Pipes?
oh, sure, pipes have copper. How about wire? No, seriously, wire. Well, pipes don't have copper so much down here anymore, but wire. People will go into these homes, they will strip out the wire. I've been in brand new houses where the buyer does the walkthrough. When you go to buy a new house, just before closing, you go and do a walkthrough, whether it's a new house or a pre-owned house, and you walk through to see if everything's okay. I've had clients call me, oh, there's no appliances in the kitchen, there's no toilet seats. So you call the seller, the developer in this case, and look, what's going on? And say, oh, as soon as we close, those will be put in until the locks are demastered, which means when the construction people can no longer get in there, then they will put the things in that can be carried away. Cabinets, great example, okay? Have you ever seen a cabinet installed or uninstalled? Cabinets are screwed onto the wall. They're screwed onto a strip of wood that it goes across the studs inside. So cabinet is really, is it a fixture? It can be removed without damaging the property. So it's technically personal property because it can be changed. Everybody, I mean, a lot of people who renovate homes change their kitchen cabinets or any other cabinets. So technically, no, it's not something that we would classify as personal property. Again, I don't have a residential contract with it, but as personal property where you would separately delineate it. Although, interesting enough, sometimes homes will be sold completely furnished. And you'll see extensive lists that are prepared by the agents, the seller, the buyer, because particularly whether it's a vacation home or a second home or something, and the party selling it doesn't want the furniture, and the party buying is going to use it occasionally and doesn't want to go out and furnish it. It happens all the time, especially condos on the east side or Aventura, places like that. In describing the personal property, one has to be careful because, a little war story, there was a 4-page list of the house being sold furnished. And on one of the pages was the master bedroom and the bed. And when the buyer got there, there was no mattress. You know what? You can buy a bed in one store and buy a mattress in another store. They are two separate components and if not properly described in the contract. So what happened, as often happens as a compromise on a large transaction, the real estate agent bought the mattress to make the deal close. Sad, but it happens. Okay, personal property. So that's, believe it or not, all of those concepts are just in the first 10 lines of this piece of paper that would become a contract. And each one of them has ramifications and implications that could lead to a problem if there's not a proper agreement, it's not specific enough. Any other questions before I move on to the best part of the contract? The money? The purchase price. Yeah.
Sorry, I was just curious with are the surveyors licensed at a state or federal level?
State.
State.
Yes. Which means when you, and I know why you're asking that question, because it means if you hire one of these national companies, they have to hire a Florida licensed surveyor to do the work. Yes. There are companies, amalgamators, if you will, that when you're doing a large transaction, you can hire one company that will do the title search, the lien search, the survey, physical inspections, the zoning reports, everything, like one-stop shopping. But in terms of something like a survey, which is highly regulated, they do have to be licensed in the state where they're doing something. Okay, purchase price. Sounds easy enough. How much you paying for the property? And that's, of course, the biggest bone of contention of the negotiation back and forth. But there's different ways to determine it, believe it or not. The easiest way, of course, is I'm going to give you $1 million for this building. Very simple. When it comes to raw land, though, there's more of a variation. Because sometimes if it's desk 1, row 3, you know approximately what the measurement of the land is, you know what's being bought, what's being sold. However, if you're subdividing a piece of property, somebody has bought large tracts of land and they're selling each tract to different builders for different things, they're going to get measured out and sold as parcels. So maybe what you do is you create the purchase price. Usually, you're not going to use a printed form for that. You're going to use a more custom contract, but still, it's the purchase price. Purchase price is going to be per acre or per square foot of land. And it's going to be computed based upon, you want to take a guess what's going to determine how much land there is? Who said it? Yes. Yeah. Of course. You hire the guy who's licensed to tell you how much land it is. and that person is also going to create a new legal description, and that's where you can't necessarily use the quarter section or the quarter section. That's easy because that's fixed measurement, you know what that is. But if you're drawing lines on the ground, basically, it's going to be a measurement, and that'll determine how much the purchase price is. The deposit. Deposit is the initial consideration for the contract. As you'll see as we get a little further into the contract, the initial deposit, while it is consideration and helps bind the agreement, doesn't have a whole lot of meaning if the buyer has the right to cancel the contract for a variety of reasons, as we'll get into. So the initial deposit is really, number one, to show that the buyer has some real money to close. And depending upon how well funded the buyer is and how much he's trying to convince the seller that he's the right buyer for the property, it's going to, the amount will vary. But usually, it's not significant as it relates to the purchase price. There used to be a rule of thumb with a binding contract that you'd want to have a 10% cash deposit because that was a number that would be sufficient to compensate the seller in the event the buyer didn't close or defaulted. But we'll talk about defaults and remedies later, and rights of other parties, such as real estate brokers, to share in the deposit if the contract doesn't close. So the initial deposit could be as small as $10,000 or $50,000 on a million, even a multi-million-dollar deal, just because the significance isn't there in terms of what can be done with it. Escrow agent is the next blank you'll see there. Fairly easy. The person that's holding the money should be trustworthy. That sounds like an odd statement, but you never know. You're dealing with a small company. Unfortunately, it could be a small real estate agency. It could be a small title company. It could be a solo practitioner law firm. You don't know who the person is. It's sad to say, when you open up the newspaper, you see people running away with money all the time. So if you're going to trust somebody, and especially when the deposit's going to get up to $250,000, $500,000, $1 million, you want to know who's holding the money. Safest, one of the safest, you go to bigger law firms are usually safe, or national title companies. The underwriters, the insurance companies that actually write title insurance, all have escrow departments. That's relatively safe.
What kind of charge what do they charge you to hold?
To hold the money? Nothing.
No.
Because they're usually engaging in another service for you. Once you're not going to go, for example, talking about title insurance underwriters. You're not going to put the money with First American Title Insurance Company if you're planning on writing your policy with Chicago Title. It's just you're not going to do that. So, and they know that. Some will charge. Some escrow agents will charge you $500, $750, or something. Yes.
Just kind of a basic question. I'm sure a lot of them know, but what is escrow? Like.
Oh, sure.
Yeah.
Escrow is when you are holding money, and please, folks, don't be afraid to ask any questions, seriously. Escrow is when you're holding money that isn't yours. You're holding it in a fiduciary capacity. You are holding the money for someone else under an agreement, and you'll see when we get down here what your duties are and what you can and can't do with that money and under what circumstances. It's held by a neutral party most of the time.
Gotcha.
Or someone who, even if they're not neutral, will act in a neutral manner because they don't want to lose their license. So when you talk about a neutral party, sometimes people will object when the law firm for either buyer or seller is designated. But if the firm is big enough, nobody's going to do anything with the money, and it's usually okay. Plus, no one's going to release the money if there's a protest. We get into defaults and things. All these questions are actually part of this contract, and it's good because you'll see as we get further down into it that all those terms are in there. That's important. In fact, if you look at the contract itself, good, I'm glad you asked the question. If you look at the contract on line 13, you'll notice that the words escrow agent are in parentheses and are in quotes. That's what's called a defined term in a contract. If you're reading either, not so much here, but if you're reading a custom contract, a contract that's drafted by lawyers, you'll see that all through the contract you're going to find words that are in quotes and parentheses, sometimes in bold to make it look better, that are you're defining it. So the blank above, where you're going to put in the name of whoever's going to hold the money, is then defined in this space as the escrow agent. And you'll see later on where that term, that defined term is used and discusses what the escrow agent has to do and can and cannot do. Line 15, you have the additional deposit. The additional deposit is where the real money comes up. And the additional deposit comes up, you'll see check boxes, because it's part of the negotiation, and the most common is the one that is on line 16, which is so many days after the completion of the due diligence. The due diligence, which you'll see again, see it's in capital letters again, due diligence period, which means it's a defined term, even though it has not been defined yet in the contract. In a lawyer's contract, what you'll find, and it makes it more cumbersome to read, but it's how we do things. Anytime you see a defined term used before it's defined, you'll usually see a parenthetical that says as defined below. It's to show that you're using it as capitalized letters because it's a defined term, but you're directing the person that the definition appears later in the document. So the due diligence period, and again, it will be defined below, is the period of time that the buyer has to make whatever inspections they want of the property to see should they buy it or not. I'll get to the conditions of that a little later. Once that time period passes, then the deposit becomes non-refundable, except for certain conditions. Everything's got exceptions, I'm sorry, it's just how it works. But it basically becomes non-refundable. During the due diligence period, a buyer has the right to say, I've changed my mind, I don't like the property, and it's also used as a negotiation time, what might be called retraining. You find something wrong with the property, you go back and you say, hey, I have to clear out 3 feet of mud, it's called muck, and then put rock and stone onto this lot before I can build a building on it. And demucking and filling is very expensive. And if the seller didn't disclose or that the property needed this work done, from the buyer's perspective, when they're going to develop a property, there's a lot of extra work that needs to be done. So they're going to come back at the end of the due diligence period. Now they've had a chance to do their investigation, which can be as simple as sticking a stick in the, it's more than that obviously, sticking a stick into the ground and finding that it's soft for 3 feet down. They use boring, of course, which means it can't hold a building. If you put a building on that, it's going to tip. So they have to spend a lot of money. Now they come back to the seller and say, hey, I now have to spend an extra $500,000 of site preparation that I wasn't planning on. I want you to lower the price by half of that, and we'll split the pain. If the seller wants to make a deal, wants to get rid of the property, they're going to grumble about it, and the price will be adjusted. That all happens at the end of the inspection period. The buyer's club, as if you will, or negotiating strength at that point in the negotiation is they have the right to cancel the contract, take the deposit back, and go away. So that's where that goes on. There's a second section of additional deposit rarely used. Line 21, total financing. This is used to put the amount in for a financing contingency. They're going to get a mortgage and they want the contract not to be non-refundable deposit, not to be what's called a hard contract until they have a commitment for a mortgage. So, question? Okay. So, I'll get to the terms of the financing later on in the contract, but that's what that blank is for on line 21, and that amount will be used elsewhere in paragraph 5. You see it says in paragraph 5. Very easy. The amount that'll be the amount of the contingency. Paragraph, line 22, other, you don't know. It could be a place for a second purchase money mortgage. It could be that as part of the consideration, the buyers agreed to give the seller a car. You could put anything in there. So, other. And then finally, the total. Although you'll notice on line 23, 24, and 25, even though there's a total which is supposed to be mathematically the difference between the purchase price minus the deposits minus the financing gives you the cash to close, you'll see little words that say subject to adjustments and prorations. There are things that are adjusted between buyer and seller in the transaction. could be expenses of the closing, it could be revenue and expenses of the closing. We'll get to a prorations paragraph later on in the contract. But then, so that number, while it's a number that's typed in there, is subject to adjustment. The final adjustment comes out on the closing statement. Okay, time for acceptance. Actually, there's several things in this paragraph 3. Time for acceptance, effective date, computation of time. Time for acceptance. Remember I said I started out talking about offer and acceptance. So when you make an offer for a piece of property and you don't get an answer right away, you have a legal commitment floating out there that is binding on you if the seller signs it as you've submitted it. So unless you communicate that you've changed your mind, that you revoke your offer, which you can do until it's accepted. So if there's an offer and there's not yet acceptance, the buyer can say, I revoke my offer, I'm taking it back because there's been no answer yet. Or by putting something here in the time for acceptance blank, you say this offer is only good for until this date, and if you don't answer me and sign this by this date, the offer is automatically deemed to be revoked. The effective date. The effective date, it's even in both letters, is it's the starting point for a whole bunch of time computations in the contract. But it is the date when the final agreement is reached between the buyer and the seller. The last signature, the last initial, the last change is the effective date. And you'll see where that is important. Okay, computation of time. There's different computations of time in a contract. There's calendar days. Well, that's real easy. Every day is a calendar day. There's business days. Business days are Monday through Friday, and actually, under federal law, Saturday is also a business day. You go to the bank on Saturday. If you're getting a residential loan, second mortgage on your house, and you have a right of rescission, Saturday counts as a business day for that purpose. So, in this contract, they're not talking about business days, they're talking about calendar days. But in a custom contract where you want more time, 10 business days works out to about 2 weeks. And really, business days would be defined in that contract, the same Monday through Friday, except legal holidays. All subject to definition. What happens here, though, is, if you see in this language, even though it's calendar days, if the time for performance comes on a Saturday, Sunday, or national legal holiday, it rolls until 5 o'clock the next day. And believe it or not, that 5 o'clock time, while you think it's just something that's typed in haphazardly, is used to enforce people's rights all the time. I've had situations where something happened with a wire transfer at a closing, a significant amount of money. The wire was initiated, the buyer was slow in getting the money to us. We got it out as fast as our bank could. The seller's lawyer got it at 5:03, and he said, you owe me an extra day of compensation because you didn't make the 5 o'clock time. 5:03. It was after 5 o'clock. Remember, it's technical. It's not subject to, it's not floating. That's why it's typed. If it wasn't, we'd all do handshakes and I wouldn't have anything to do. Closing date and location. Location sounds easy, but boy, do we fight over that. I don't want to leave my office. It used to be more customary that people for a closing would go to somebody's office and you'd sit down around the table, you'd talk back and forth, you'd sign papers, you'd pass papers back and forth, checks would get passed back and forth. The closing is everybody happy, and the real estate agent would come in with a bottle of champagne. People don't do that anymore. People don't sit down, especially on larger commercial transactions, because there's big stacks of documents at either end. Somebody is signing all kinds of loan documents to finance big transactions. So they're in their lawyer's office with all the loan documents, and they're FedExing everything, or they're scanning and emailing everything to the bank or to the bank's lawyer. That's done in one location. The sellers pre-signed everything and signed all their resolutions. The only thing that's still maybe floating around is a couple of dollar adjustments at the end. So the closing location isn't so bad. Really, it used to always be, under the terms of the contract, does it even say anymore? It used to be the seller's. Oh, there's a blank. It only says what county, it doesn't say who. But when we get to the designation of the closing agent, later on in the contract, that'll dictate the who and the where. But it used to be a fight because nobody wanted to go out of their office and drive to the other person's office. I remember when I was practicing in Miami, I would be as the youngest associate, I'd be the one sent to West Palm Beach. And that was a pain, but that's, we didn't have the electronics, and no one would ever think of sending a FedEx from West Palm to Miami. That just was, yes?
Is e-sign regulated in Florida yet?
Say it again?
E-sign, e-signature?
It's being used for residential transactions. It's being used for contracts and commercial transactions. It is not being used for only, no, not for closings, just for contracts, not for deeds and things like that. Deeds, they still want a real wet signature. Although you can e-record, but to e-record you have to have the real original in your hand. So, the closing date. There's different ways to define the closing date. The one way you should never do, ever, ever, ever do, is on or about. You know why? What does it mean? About? On or before is okay. On or about is maybe here, maybe there, you know, it's fun. You don't write contracts that way. On or before is fine, but then maybe there's a restriction as to who can determine the before. In some situations, sellers occupying the property, they don't want to get out. Or the seller's got revenue coming in, they don't want to lose those couple of extra days. So the or before may usually not used. So usually there's two ways to do it. There's a date certain, which is becoming less and less common, and you'll see why as we get into the other days. Or, more likely, X number of days after the end of the due diligence period. So that will determine when the contract is, and it does not count the day of effective date, which is the day it's signed, or the day of the due diligence period does not count. It's days after that counts. A little bit, again, it's technical, but you know, when people are, I don't want to say being nasty, but when they're being strict because the deals are tight, they will use those things to measure whether or not you've actually performed the contract or not. Just like you may not like it, but that's how it is.
So just to kind of dive into that one a little bit, if there's a 30-day due diligence period,
Right.
and they say after the end of it, if the contract's accepted in the first week, is there still a wait till the end of the due diligence period? Like if the contract's,
Go ahead.
they investigate the property, they
Right.
like it, they buy it in the first week, and it says closing date after the end of the due diligence period. Is the end of the due diligence period when the contract's signed, or is it at the end of the full period?
Okay, in your example, you said they had a 30-day due diligence period, and after 7 days, they've decided they're happy, right? So at that point, the buyer's going to write a letter that says, I accept the property, and I hereby end the due diligence period.
Okay.
So now, when you go back to that, and it says the closing will take place 15 days after the due diligence period, the buyer may also say, hey, I'm ready now, do you want to close? And the seller is jumping up and down because he's going to get a wire transfer. So he's very happy, and yes, the closing takes place early. Any more before we move on to third-party financing provision? Okay, so starting on section 5, remember I called your attention back in the money section to the financing contingency, and it even gave you a preview that said see paragraph 5. So this is a provision that's called a contingency. A contingency is a condition. When a contract is subject to a condition, if the condition is not fulfilled, then the performance is not required. So here it says if you don't get a mortgage, you are not obligated to close on the property. But this whole big paragraph is obviously a lot more complicated than those simple words, because it's going to define what you're allowed to use as a contingency, what terms you must accept, or what terms are defined in the contingency. Let's look at it. So the first thing it says is the buyer has within 5 days to go make application to the bank. Not difficult. Within 5 days after what? What's the magic words? There we go, effective date. That's why the effective date is so important. That's why it's a defined term. So they have 5 days after, not including, after the effective date, to just go and make application to the bank, fill out all the papers. Then it talks about all these blanks that are in this paragraph, all the different things. So what's it's an interest rate, sorry, an amount not to exceed blank % of the purchase price. Why is that important? Because, what's that? But, yes, financing, but how much can you get? How much can, if you're a bank, and I'm gonna buy a piece of property for $1 million, are you gonna loan me that whole $1 million? Why not?
Risk.
Right. I have nothing in it. I have no skin in the game, as they say. So this talks about what percentage you're allowed under the contract to apply for under the contingency. Now, understand, the fact that the contingency limits you to, let's say for our discussion, 70%. If you put the 70% contingency in here, that doesn't mean you can't get a bigger loan. It means that if you're approved for at least 70%, then the contingency is satisfied, at least as to the amount. If you're approved for 80%, great, you only have to put 20 down. But if you apply for 80 and you're turned down for 80, but you could have gotten 70, you have not failed the contingency and your deposit's at risk. And if there's two ways, there's two blanks there, one is it's a percentage and one is it's a dollar amount. Then it talks about in line 48 an interest rate. You know, when you're doing an analysis and you want to buy a piece of commercial property, you know what the income is, you know what the expenses to operate the building are, and you can only pay so much for the mortgage. As interest rates fluctuate over time, you want to protect yourself as a buyer as to the highest interest rate you can live with and still close on the property. So you put a cap on there, 5%, 5.5%, 6%. It's funny because as interest rates have crept up a little bit and we're now looking at things in those 5 to 6% range, people are, oh, interest rates are so high. I just pulled out of a box of old newspaper. I'm not even sure why I saved it. It's very old. It's from 1982. And the interest rates that were being advertised were 14.5%. So, when you look at a 5%, 6% rate, it's not so bad if you've been around and you know what has gone on historically. I don't know, hopefully we'll never get to those again. But so there's two kinds of interest rate mortgages you can qualify for here. One is fixed. Fixed rate mortgage means you get a 6% loan, you get it for 10 years, and that payment never changes, and the interest rate never changes, and you know what you're paying for the property. That's safe and it's easy. It's also a little more expensive. Or if you want to start out with a lower rate, you can agree to take a variable because you've got all these blanks are in here that say what you're willing to accept. Variable rate mortgage. Yes.
Speaking of the blanks, I see in parentheses where it says, if left blank, then,
Okay.
Is that actually considered a meeting of the minds?
Yes. So what that is that's what's called a default amount. Not default like you haven't performed under the contract, but there are some situations, computers and things like that, if you don't make a choice is made for you, and that's called the default choice.
Right.
So you can either pick that door or that door, but if I'm walking straight this way and I don't change my mind, I'm picking that door. Okay, that's the default choice. So here, this is put in as a protection for people that aren't paying enough attention to the blanks. And they don't know what to put, they don't think about it, and if they don't put something in, it's 5 days. And you'll see that in various places in a contract. So that's what the parenthetical is. And yes, it's a meeting of the minds because they've agreed, the meeting of the minds has been that if we don't put something in there, this is what goes in that blank. The term is spelled out, yes?
Why is it even third-party financing even included? Because if you're purchasing it from
Go ahead.
two people having or selling and buying land between each other, why do I care where you get the money from?
Are you the seller?
I'm the seller.
Okay, so I come to you and I'm going to buy your building for $1 million.
You show up with $1 million check, I'm good with that.
When am I going to show up with the $1 million check? At closing, right?
That's right.
So you're taking the property off the market. You've allowed me to inspect your property, to do all the things, and do you know I have that $1 million?
No, you don't have the property yet either, but I see what you're saying. Put me in kind of a
I'm wasting your time,
yeah.
right? Now, so in that circumstance where it's cash and you're not going to go through this, you're going to ask for, anybody want to come up with a magic word? Proof of funds.
Yeah.
You're gonna want me to show you that I have that $1 million so that I'm not wasting your time, because otherwise, you're gonna try and sell the property to somebody else instead of sitting there waiting to hope that I have the money. So you asked a good question. Why is there a financing contingency? Now let's flip it around and you're the buyer. And you wanna buy this piece of property from me. And you know you don't have the $1 million. You know you have $300,000. And you need the other $700 from the bank. But you don't want to put a deposit down on here and risk losing $10,000, $20,000, $50,000 as a deposit unless you're pretty sure that you're going to get that $700,000 from the bank. Now, to make deals simpler and go smoother, what will often happen is a buyer will go to his bank first and get pre-qualified, which means the bank will look at your finances, look at your credit, and say, okay, we are comfortable that with the right property, we will loan you $700,000. Now, I say the right property. Let's come back to the question of the loan-to-value ratio. If you go to the bank and you say to the bank, I'm going to buy this property for $1 million and I want $700,000 of a loan, and the bank's policy on a commercial transaction is a 70% loan-to-value, the bank needs to evaluate that the property that you're paying the $1 million for is worth $1 million, and that's called an appraisal. That's where they hire a third-party expert who goes out and evaluates what that property is worth so that they know that when they're loaning you the $700, it's no more than 70% of the value of the property. Now, why is this contingency important? Because if you go to the bank and either you haven't been pre-qualified or the property doesn't appraise out, or there's something else wrong that they won't loan you the money, you can get your deposit back. Now, from a seller's standpoint, the seller wants to be protected that you're just not going to change your mind. So that's what all this, there's a lot of verbiage in this financing contingency paragraph where the buyer, if you just take a look at it, you can see the buyer's obligated to provide all credit, employment, financial, and other information reasonably required by the lender. They have to cooperate. They have to use due diligence. They have to disclose things. And then it says, how much time do you have to obtain the loan approval? The default in the parentheses is 45 days. If it's a peculiar kind of a loan, for example, you're buying the property because you want to put your operating business into it. And that's really the best kind of a loan for the bank. But you also need SBA financing for the business because you want a package of financing, and you don't have 30% to put down. So you're going to put an SBA loan, which is going to cover some of the gap. It takes longer. So you're going to want your financing contingency to be longer. Even though it's really good from a credit standpoint, because it's an operating business and it's not just an investment, you're not going to walk away from the building, it takes longer and it's good processing.
Is SBA secondary or primary?
Secondary. It's a second mortgage, and it buys the mortgage is originated by usually the same bank that does the first, then SBA buys it from them and takes an assignment.
SBA?
What? Oh, I'm sorry, Small Business Administration.
Oh, okay.
Don't let me acronym you. I hate that. I hate doing that to people. I apologize. Okay. It goes on in this paragraph to say that you're going to keep the other party fully informed, tell them what's going on, tell them what the bank is saying, and let the seller know, let the brokers know, let everybody know how you're doing with the financing. Are you running into any problems? And then, of course, if you can't get it, using good faith and reasonable diligence, it's spelled out right in there. It's not words that are being made up. If they don't get the loan approval by the loan approval date, you notice it's capitalized again, which is defined up at line 54. All these terms, by defining the terms, you can use them all the way through the contract. So if they don't get it by the loan approval date, then they have 3 days to deliver a notice saying either one, I'm canceling the contract because I don't have the money, or I'm waiving the financing contingency, meaning I'm taking the risk. I'm putting my deposit at risk. I think I can get the money from my uncle. Or I can get the bank to give me the money. It's just going to take me a little longer. I'm confident. I want the property. I'm taking the chance. The seller at that point would be entitled, if the contract didn't close, to keep the deposit. Okay. I want to see if there's anything major left in this. if it's terminated, of course, the buyer gets the deposit back, and then everybody goes away. Oh, take a look at the very last sentence of that paragraph. Remember I mentioned a pre-approval letter? A pre-approval letter is just a letter from the bank that says, we've looked at your credit and you will qualify for a loan of this amount, but that is not loan qualification for purposes of this financing contingency. So the seller can't say, hey, you gave me a pre-approval letter, you waived it. It's not. Next section is title. Title means a lot of things. Title is ownership to the property. So what's being discussed here and what gets evaluated in this section of the contract is the quality of your ownership and what you are agreeing to give to the buyer, what the buyer is agreeing to accept. First, there's a choice of different kinds of deeds. I don't want to delve into that in great detail now. I'm going to save that for a later class because it gets complicated and I don't want to overdo it. I'm trying to make this, going through the contract, is more of an overview of the transaction. But it says free of liens, obviously, and subject to a variety of things that are in this paragraph. All that are involved in the examination of title and things that can affect the quality of what you're buying and what you could do with it. So then, there's another provision that says that the buyer will accept all of these things as long as they don't prevent the use of the property for. And now you have a blank. Well, this blank is important because you could say in that blank for a retail store, but that retail store may not permit you to have a cannabis dispensary. So if the buyer is planning on opening a cannabis dispensary in that location, then you better put that in there because if any of the restrictions prevent that, the buyer can get their money back. That's a whole other topic. You may think that's an amusing side, but I happen to do a lot of leases for the cannabis industry because my law firm's involved in it around the country, and you can't get a mortgage. So there's all kinds of, hopefully we'll get to that when we get into leases and other things because it's really very interesting and it's something that you never think would have crept into the legal practice, but it has in a very big way. And it's really very fascinating. Okay, evidence of title. It starts off with the allocation of who pays, and who pays determines a whole bunch of things. Title insurance is expensive when it relates to a piece of commercial property. It's in the tens of thousands of dollars when you get up into the multi-millions, and usually in most areas on commercial property, the buyer is going to pay for the title insurance. They're going to have the title examined, and they're going to insure their title and their lender's title. What is title insurance, you might ask? Title insurance is actually an insurance policy that is issued by an underwriter, a national company, that after examining the title and after your deed is recorded, says that if there's something that pops up as an encumbrance, a lien, a defect in your title that causes you a loss, they will either pay or defend. They will either pay to get the cloud removed from your title, and again, I'm going to get into title examination and clouds and things like that in more detail in another class, but basically that's what title insurance is. It's protecting your title. It's ensuring that you have the quality of title you're paying for. So you go back and forth as to who pays for it. In residential transactions, who pays for the title insurance varies from county to county. Commercial, it's usually negotiated and it's usually the buyer. It's dollars, it's all about the dollars. But here it talks about there's other things that are related to title insurance, such as the examination of the title, which is a search of the public records, lien searches, closing services, who you're going to hire to actually go through the transaction, through the paperwork, assuming that there's no, well, even if you have, each party has their own legal counsel, some people use title agencies, and there are services that have to be paid for, and unlike the escrow, there are fees for this. So, who gets to pick? Well, here's a little quirk about the title insurance. a title insurance agent, could be a lawyer, could be an independent agent, gets paid a commission, a portion of the title insurance premium that's charged at closing. When you're talking about larger transactions, it's a lot of money. So in my practice, for example, if I'm getting a big premium or big commission from the title premium, I'm going to reduce the amount of fee that I'm charging to my client for the services I'm providing because they're compensating me in another way. I want to be fair. I want to be paid fairly for what I do, but I also don't want to be overcharging the client because you'll lose business that way. So you give them a rebate for a portion of what you're making on the title insurance. So the people, buyer and seller, are going to fight a little bit back and forth as to who gets to write that title insurance because there's a financial benefit to the party who's paying for it, who's going to get a break on the closing costs, on their fees. Once upon a time, evidence of title was done by examining an abstract of title. When we get into title, maybe I'll bring an abstract in to show you what it looked like, but it was in the simplest form, it was a book, legal length, about the thickness of a telephone book. Anybody remember what a telephone book looks like? I just realized the example is stale, but so it literally has in this book the history of the parcel of land you're talking about, going back to the time when the King of Spain gave the Floridas to the United States. And every entry from there forward of everything that's happened that affected that piece of land. Now there are statutes that clear some of that up, so that you really only have to go back 30 years, but and in today's world, we're not using abstracts anymore. Everything is done by the title underwriters. They provide a search. I have title insurance. I give you my prior policy. They only do a search for my prior policy because the title's already insured. So it's simplified. But once upon a time, we had to actually examine abstracts and look at the history of the title and determine manually what happened. So when you get your title commitment, which is what's with the first thing that comes from the underwriter, it's got the basic information as to what's necessary to convey the property. There's exceptions. There are restrictions that are recorded against the property. Now, in many cases, it's things like, remember I described the plat to you, which was the map? Well, when you do when that plat gets recorded, that map gets recorded, and it describes each individual parcel, like each desk, then the question is, how do you get to each desk? Well, a plat would dedicate roads, streets. The streets that you have in your neighborhoods are all per the recorded plat. Except the question. That was parts of Weston. But it becomes private easements, and they're dedicated, but they're private, and it's a little quirkier, because then if you're in an association with a private easement, then it's got to be maintained. Like I used to live in a house in Davie, and we had private roads. Once you get inside the gate, it was the association's responsibility to maintain the streets, which is not good if you have very few houses, because when it needs to be fixed, people have to pay exactly. That's not good. So there's deed restrictions. Deed restrictions can be anything like you can't have a dispensary, you can't have a slaughterhouse, you can't have whatever it is. When someone is developing a piece of property, they have the right, as long as they are constitutionally legal restrictions, to restrict the use of the property into the future. Okay, so there was an airport, a private airport, in Broward County a very long time ago, which was owned by a family called Foreman. And when the Foremans decided to donate this property, they put a restriction on it that said that this land that they were donating could only be used for one purpose into the future. Anybody want to guess either? I know you know.
Hospital.
I'm disqualified.
Right.
This campus?
Yes. Sorry, man. So I just knew you knew.
University.
That was a good.
You're sitting on it.
Oh, this one. Well, I think it was two.
In Miami?
I forget.
Oh.
Yeah.
I don't know that. I don't know the history of that parcel, but you're probably right. But this was the Foreman Airport. If you go back far enough in time, again, I'm all about bringing in the graphics and things. So I have somewhere in my office, not somewhere, I know where it is, it's enormous. It's literally this big. It's a 1959 tax map of Broward County, and it is fascinating because it shows all of those things. And when I started my practice, I'm talking about the abstracts. I started off examining abstracts. I would do 8 or 10 a day, 6 days a week. And that's a lot of land to learn about. And you learn about all the history of what went on. You know, this was desolate out here. There was nothing out here back in the earlier days of the county. Of course, there was one point in time where there wasn't a Broward County.
So I know that the restrictions run with the land.
Yes.
What's the process called whenever you attempt to remove them?
Ooh. That's difficult. There's a couple of, I mean, it depends on how much of the land you own. If you own all the land that's subject to the restrictions, and the restrictions do not benefit someone other than this land, then you could record a document amending or removing the restrictions. However, if you have restrictions saying that you can't put, I don't know, use a slaughterhouse for an example, on this tract of land, it's because there's houses next door. So they're benefiting from this restriction, and they bought that property knowing this restriction was on there, so they are benefiting as well. So you can't change it.
How do you prove they knew?
It's in the public records. Everybody is held with knowledge of what's in the public records. So go read everything that's in the public records.
Is it, that's why there's so many schools out here? Is that why?
Yeah, this whole area right here, yes.
This wasn't a plan, it
No.
was like an educational area.
It was planned because it was donated for that purpose.
I see.
Yes.
And would that be the same like within Parkland where they can't have certain types of businesses within certain lines because there were restrictions put?
Yes.
Huh.
Now, there's another, and
The
again,
city put the restriction when it
Say
comes
again?
to that? Like when for businesses, is the city that put the restriction?
No,
the CD?
the city.
The city.
Oh, city. Sometimes, so I'm just gonna say that, it's funny you bring that up, because there's two kinds of restrictions. There's a recorded, here I'm talking about title. So in talking about title, I'm talking about documents that have been recorded by developers or private, as opposed to zoning. Zoning can be done by the city, zoning can be done by the county, or both, in which case it gets more complicated. So yes, the use restrictions are governed by both. Usually your basic land use is done by zoning. The restrictions are just there for private. Okay, I'll give you some examples, some simpler things, and I can bring you examples when we start to talk about title in more detail. Take the neighborhood, I've talked about the neighborhood I lived in Davie. So it's a neighborhood of 35 homes, it's gated, and once upon a time was actually part of Orange Grove. But Davie, the town of Davie, as a zoning matter, says the single family residential lots out there have to be an acre. That's how Davie keeps it country out there. However, within the community, there's restrictions that say garages have to be side-facing, not front-facing. Because whoever developed it didn't want a situation where you're driving down the street and you see people's open garages with all their junk inside, okay? Because people don't keep their garages neat. Or, I'm trying to think of other things that were in those declarations. Houses have to be a minimum square footage. Because even though the town says you have to have an acre lot, they wanted to say that this is a nice neighborhood and your house had to be, and you see this all over the place, your house had to be no less than 3,000 square feet. And you can't have a shed, and you can't have a tin building, and you can't have a mobile home, things like that. Those are all restrictions, and when you go to buy a house there, if you don't want the restrictions, don't buy there.
You can fight.
No, because it's there, the restrictions were there first. However, if somebody had a restriction that said, nobody can buy a lot in this subdivision if they have blue eyes. Okay? I'm using that to be a little more politically correct than what the restrictions really do say. And that's unconstitutional. I'm assuming it's a protected class. Obviously I'm using blue eyes. But for example, I had a house closing I did. My client is Israeli. When I got to the restrictions in a community on the east side of town, it said in the deed restrictions, no one who was more than 1/4 Hebrew or Syrian blood could purchase. Now this is back in the 50s, 40s and 50s.
Are you reading it in your book of?
Yes.
It's not still like that, I mean.
It's physically there, but it's unenforceable. Those restrictions are completely unenforceable. But those are exactly the words. Well, this guy, who happened to be a real estate developer, had never heard of such a thing. And when I showed him this restriction, even though I told him it was completely invalid, he was flabbergasted that it ever existed. And I mean, this is the developers that did that area and other parts of town, that's what they did. And, you know, but they're not valid. So those are restrictions that are in the public records that they'd be in the title. But if you ever saw a title policy, it's going to have an exception, because that same document with those invalid restrictions is also going to have the minimum square footage and, setbacks. I forgot to mention setbacks is another possible restriction, that no building can be built closer than 25 feet to the lot line. It gives you a yard. It makes it, makes the neighborhoods look nicer. So you have to have that restriction as in your title policy, and there's then going to be a sentence in there that says, but omitting any restriction referencing race, religion, national origin, and I forget what all the other words are, to recite that even though this is an exception, those portions of those restrictions are not valid. Yes?
So like in the case of what you just said about you can't build to like a certain extent to the lot line, like in which case, unless it's like the initial purchase, is that relevant? Because like if I'm selling the property, why the hell do I care where you build? You know what I mean? Like
You know, your neighbors do.
No, I know, but that's what I'm saying. So like if I'm selling the property, like why would I have it in? Or is that something that's been kind of like historically from the initial purchase that like the homeowners association put in?
It's not in your specific deed. It's in a document that is recorded in the public records that applies to the whole room.
Gotcha.
It's not just your desk, it's the whole room.
It's the whole neighborhood or something like that would be.
Even though we're shuffling desks around in here, like shuffling lots, the restriction would say that you can't put your desk closer than 3 feet to the desk next to you.
Gotcha.
It's not for you, it's for them. Okay? Same thing with the house. We don't want the house crowding the lot.
And this would be uncovered in the title examination?
Yes.
So, are covenants and restrictions recorded with like the local municipality or the state?
County.
Okay, the county.
County. All real estate documents are recorded in the county.
So basically restriction are kind of, let's say someone owns a property, they can put it, like they zone the property, they want it a certain way.
Well, zoning is different. Zoning is governmental.
Okay.
I'll give you another perfect example of a private restriction,
Okay.
because I encountered this, and these are examples from the true files, as they say. Client bought a building that had been owned by McDonald's. McDonald's moved down the road and built a new restaurant, and they sold the old one. Which is sometimes unusual. Usually they'll tear it down and they'll build a new one on site if there's enough room, if the location's okay. They didn't. The deed from the McDonald's company to the next owner said, no one owning this property can operate a restaurant selling hamburgers, chicken sandwiches, and it was very specific, and a whole list of other things. And so when my client bought it and wanted to do things, he had different potential tenants, including, it was built out as a restaurant, so, but the menu had to be restricted, that they couldn't have these particular things. That's a private restriction, and it's put on there for the protection of the person who sold the property. In that case, in your example, your question, the seller did care what was done with the property, because they don't want
competition.
Because they don't want competition, correct. Now, I was just dealing with a lease, bless you, a ground lease up in Tequesta for a Burger King. And the lease provides that no other the landlord cannot lease to any other tenant in the shopping center that sells the usual things that you find on a Burger King menu. Well, what happens if the operators, remember it's usually a franchise operator, it's not Burger King corporate that's operating it. What happens if they go out of business? What happens if they're no longer operating?
It doesn't benefit anybody.
It certainly doesn't benefit them, and it's putting a terrible burden on the rest of the shopping center. So we had to negotiate a provision, we're not done, we had to negotiate a provision on what circumstance does this restriction go away. So the tenant, who's a franchise operator, came back with the tenant's lawyer with a provision that said, if the restaurant is permanently closed and we send you a letter that it's permanently closed, then the restriction goes away. Anybody like that?
No.
Why?
It's too much.
What is permanently closed?
No, it's the letter.
Look, okay, what's permanently closed? They're closed for business, and in their version, they insisted that they send us a letter that they were permanently closed.
What's the incentive? They don't have to send a letter.
What happened if they move?
Yeah, exactly. Or better, or worse, you got it. What's the incentive for them to send letter number one? Number two, what happens if they go out of business and vanish, and the letter never gets sent? So we turned it around. We turned it around and said, if you're closed for more than 60 days, and you haven't sent us a letter that says you're renovating, then it will be assumed that you're permanently closed. Remember, the tenant has a huge investment, because in this particular case, it's a ground lease. They're building the building. They're equipping it as a restaurant. They're operating it as a restaurant. So they have a tremendous investment in the property that they're looking to protect as well. So that's what goes on in the back and forth in negotiating provisions like that. Okay. Title examination. It's good. This is great discussion, by the way. I hope it's working the way we're doing this. Title examination says once the information is provided to the buyer's representative, you have so many days to review it and to raise objections. Well, we've all talked about a bunch of things that could be potential objections. All kinds of restrictions that would keep you from being able to use the property. Typical things that are not controversial that get taken care of and are not covered in this form of contract, would be covered in a more sophisticated contract, would be that the seller says, whatever you object to, I am going to then have a decision to make as the seller whether I want to spend the money to fix it. Do I want to go out and get that restriction removed if it's going to cost me $100,000 to go buy somebody's signature to get that restriction removed? I, as a seller, want the right to be able to say no. If it's a simple thing of going down to my neighbor and getting a quitclaim deed because there's a cloud on a piece of property, that's different. But I, as a seller, want to be able to make that economic decision. However, the exception that does not appear here, this whole cure issue does not show up well in the form, is if it's a mortgage or a lien or a judgment against the seller or money that the seller's bought, they should be obligated, without having the right to make a choice one way or another, obligated to remove that cloud from the title. Simply the payment of money. Next section, as a corollary to the title examination and seeing what's in the public records, is the survey. We've talked about what a surveyor does. I brought a survey to show you, but I don't have the projector. It's a teeny tiny little print. It's basically, it's a sketch of the property done by the surveyor, a registered licensed land surveyor, who goes out and physically measures and physically draws a picture of everything on the property. The problems that pop up are if my house or building encroaches on the land of somebody else, and it happens, where when it was built over a little bit too far, and it's over the line. It could be as simple, I had this in a zero lot line office park, where when they did the survey, they didn't take into account the fact that the roof overhangs, the eaves, extend beyond the perimeter of the building. So if the building was in the lines, the eaves weren't. So we solved that by doing an encroachment easement for about a foot from the association that owned the parking area to each building owner for this encroachment for the eaves. We talked about setback lines. If it encroaches on a setback line, that could be a title defect. Could be a situation where you find that your neighbor's property is encroaching onto yours. More likely what happens is fences. The fence is put in the wrong place. And you gotta be careful, because if that fence is left there long enough, under the right circumstances, it's, yes, adverse possession, which means it's a way that you can actually acquire an interest in the adjoining property. That's beyond the scope of what we're talking about here.
So,
Farmland.
It comes down to like inches too.
when you talk about the overhang and the
Yes.
and you said you got an easement, does that mean you like purchased that foot or 2 foot space? or
No,
what does that
you
mean?
just got the right. And, okay, so, sorry, again, I'm gonna talk more, I'm trying to use the contract as a beginning overview, but I'm gonna talk more during the course about
Okay.
property rights and easements. No, but I wanna answer your question. So an easement is a limited right granted by a property owner to somebody else to use the property owner's property for something. The most common use of an easement is for ingress and egress. A private street, I bought this piece way back here, and there's no real roads, and you own all of that, and I need to get to the door. So you give me the right to cross this path for the purpose of getting out to the door. That's a typical easement. In the overhang situation, which I even have on the podium here, where it's the top of the podium extends beyond where the foot is. So, or in the encroachment situation, where my building is built and it's a foot onto your property. Rather than fight about it because it's really not bothering you, you give me the right to maintain my building on your property on the 1 foot. However, if and when that building gets demolished to be reconstructed, the easement automatically goes away and I have to rebuild within my lot line. That's why it's an easement and you're not buying it. You could buy it. I mean, if you wanted to sell me a foot of your land, assuming that zoning would permit that to happen, which it doesn't always do, and it wasn't violating minimum lot sizes and things like that, you could do that, but it's permanent. An easement doesn't have to be permanent. It usually is permanent. Now, this easement here might be limited since it's over your land. If in the future the city comes along and puts a road that says I can go down here to the back and go out to the back door to a public road, you now say, okay, you can't use my easement anymore because you have another way to get out. Okay?
And by acknowledging, like back home, farmland, adverse possession is a big deal. You put your fence here, but the way that they defeat that is by, saying, or registering with our attorneys back home, yes, we acknowledge that your fence is on our land, as long as it's recorded, theoretically they're protected.
So, give me another word for that acknowledgement.
I don't have it.
Are you allowing me to keep my fence on your land?
Yes.
And that's called
I don't know.
permission.
Okay.
Okay. And so what is the legal doctrine you are talking about?
Don't know.
Adverse possession.
Okay.
Okay, you said it. That's why sorry, I don't mean to be strategy.
Yeah.
The person can say no for the easement, and the right to say no as well, your neighbor.
Like for utility.
I'm going to give you a hard maybe on that. Okay?
But let's say they say no, can you go to your
Here's the problem. There's something called an easement by way of necessity,
Yeah.
okay,
where I'm literally landlocked.
okay.
And
They
if
must like.
worst case scenario, where he sold me my land back here, okay? But didn't give me the easement. Now, I said, well, wait a minute. You sold me a piece of landlocked land. I have to be able to get on and off my land. It's an easement by necessity. You
Yeah.
have to give me the easement.
Yeah, that's true.
Adverse, I'll touch on the adverse possession because, again, I don't mind jumping around if it's okay with everybody. And if you've got questions, please bring them up because to me, the information in context when we're having the conversation anyway is better than just raw information. One of the elements of adverse possession is it's got to be hostile. Notorious, hostile, adverse. Hostile means it's without permission. Notorious means you can see it. Adverse means you're excluding the property owner. That's the fence. In Florida, I think you have to pay taxes as well, or
7 years.
you have to return it on your tax return. You have to, your property taxes, you have to block it off. It's not easy. It's much more effective in a rural environment where people aren't using the land. than it is where you're gonna keep up somebody out of their swimming pool. So,
Yeah, we've seen huge tracts change.
huge, yeah.
300 acres and more.
Must be one or all vehicles that you said?
All,
Three for 7 years.
yes.
And how would a cross-access agreement, is that the same as the, like, legal thing that was?
Ooh, good one. Question was, what is a cross-access agreement?
Well, would it, like, be one of the things that we put in a doc, because I worked with those a lot.
Okay, so that's back and forth easements, basically.
Yeah.
So let's go to the shopping center that I was talking about, the Burger King again. So the shopping center, take the room for example, okay? And in the back of the room is a big billboard building. Or to be a little more specific, let's take this long set of tables here as the main shopping center parcel, and we have out parcels.
That's exactly, I just worked on a project.
Okay, it's the Pollo Tropicalo's here, and the Wendy's is there, and the whatever, they're all out parcels. But the shopping center has a series of driveways and parking spaces. So it's a little more than just a cross-access easement, it's a little more complicated of the document, but basically it allows these people to cross over and around and near where the other out parcels are, and more importantly, the out parcels to come around and use the driveways of the shopping center to get in and out. And you see examples of that all over around here. I mean, and shared parking spaces. Well, that's a whole, I could go on for,
I couldn't agree more.
shared parking spaces you can go on for, and there's things like, you have a hotel and an office building on the same tract of land. By sharing the parking, when are people going to use the hotel parking spaces? At night. When they use the office spaces during the day. So you can't, it's not all of them, but zoning requires a certain amount of parking spaces for a certain type of use. If you don't have enough parking spaces, or you don't want to build enough parking spaces for both uses, you can declare that it's going to be shared to an extent. Not 100%, because you can't be 100%, but knowing that the two uses are going to be at different times, you can restrict it and do it that way. I just had one with a restaurant use as part of an office building. Because, but what the city will do as part of approving that use, because these are all things, you're not going to get your building permit to build your improvements unless you have enough parking per zoning so that you can, people that are coming to the restaurant or coming to the office have places to eat. You have, this particular one that I was reading the other day, the restaurant was not allowed to open until 6:30 at night because of the parking restrictions.
I was working on a project once where we were looking at developing the out parcel of land, and then the anchor tenant for the large shopping center had a line of sight restriction. So I had to design the building to have a completely separate view on the out parcel, just so the anchor tenant behind them just would have a line of sight to the road, so people could see it. So we had to completely design the building just so people could see the building behind it.
Well, but think about it. If your Target
Oh, absolutely. I mean,
or Costco or whoever you're talking about, you want your customers on the street. Now, yes, there's going to be a pylon sign by the road, but if you're not looking up and you happen to be looking at the shopping center, oh, there's the Target.
Yeah.
Okay, so that line of sight is very important and it's very heavily negotiated. As are parking restrictions. Well, there's so many. What's fun to me about real estate practice is all these tangents. There are all kinds of things within the real estate law. Hopefully we'll touch on little pieces of it everywhere. You almost be doing something that you like it as well, or you wouldn't be in this program. But there's all kinds of tentacles of real estate that there's different aspects for all kinds of things. So let's come back to our friendly comment. To the property condition.
Good.
Paragraph 7 talks about the property condition. And it basically says that the seller will deliver, it starts off by saying the seller will deliver the property to the buyer at the time of closing with the same condition it was at the time the contract was entered into. And that's important because things happen to property. And hey, I bought this with that building there, not after the fire burned that corner of the building down. or the hurricane blew down the sign or something. So that's the first thing. It also says this minus ordinary wear and tear. The seller agrees to maintain it in this provision. But the most important part of this section of the contract is actually starts on line 26 and 7B, which is the due diligence period. Remember, we talked about that earlier on. I briefly touched on, we were talking about the deposit, the additional deposit. The due diligence period has a couple of different names. Sometimes it's called the due diligence period, sometimes it's called the inspection period, sometimes it's called the investigation period. It's all of those things. It's the opportunity for the buyer to examine the property, both physically and financially, to determine that the property is acceptable as represented it was going to be in terms of representations as to what you could do on the property, and representations as to how much you're going to make. Because if you're talking about commercial property, you're buying a shopping center, for example, or an office building. You're not just buying sticks and stones, you're buying an income stream. So you want to look at the rent rolls, you want to look at the leases, you want to look at the expenses, all part of the investigation period.
Audited statements, audited financial statements.
Sometimes yes, sometimes no. It depends. Who are you? Are you Joe's Shopping Center, or are you Kimco? Kimco's going to have audited financial statements for sure.
Oh, who would have them?
Who
Or who
owns
would
it?
ask
Right.
for them?
Joe Shopping Center, not so much. And right, and in a lot of situations, especially when you get into the smaller shopping center type owners or any kind of property owners, it gets less and less formal. Which is good and bad because, you know, a sophisticated buyer, and there are buyers and developers and people who look for different kinds of things. I have one client who just loved, he's gotten a little bit away from it, loved to buy B and C class properties, which is generally categorized as crap. And you'd look at the thing and you'd go, oh, why are you buying this? And here's what he explained to me. He said, if you go to a sophisticated shopping center, with a big box or with a national tenant, they're going to come in and they're going to say, how much is it per square foot? And how much are you going to give me in tenant improvement credits? And how many months free rent are you going to give me for signing this lease with you? And what are you going to do for me here? And what about my signs? And what about all this? Okay? That's complicated. It's burdensome. You get a great credit tenant at the end of the day, but it's one way to do business. On the other hand, when you have your C-class tenant who's operating a small business and sees the sign and comes in to inquire about the shopping center space and sees the storefront, he's not asking you how many square feet is the storefront and how much per square foot are you charging me, and he has one question and one question only. How much a month? That's all he cares about. Because he knows that if you're going to charge him $2,500 a month, he knows how much business he can do, and he knows whether or not he can afford that, and he knows whether to put his store in there. Well, when you're doing that in these smaller places, the rent per square foot, when you're just throwing a number out like that, can be so much higher than what you're going to get out of a quality tenant in a quality space because nobody's paying attention to it. But if you actually do the math, it's much higher. Now, there's much more risk because there's much more chance that little guy's going to come out and go out of business. He's an independent operator, as opposed to, you know, if, well, probably should be a bad example, it's Sears, but if, sorry. But if you get a, well, no, I'm gonna use a small national retailer, for example. No, that's a big, Macy's usually owns their pets. A small national retail, Gap. Who? Public.
They have a lot
Pretty
of
big.
You don't want to deal with Publix.
Yeah.
Great tenant, there's a lot of grave damage because Publix knows that they're the 800-pound gorilla. And they know, but so now what happens with public shopping centers, great tenant, no question about it, great store, great company, but they're gonna put things in their lease that say no sandwich shops. Okay? So when you want to put the Laspadas in there,
Oh, yeah.
I love getting voices like that, thank you. They're going to say no. However, they're going to let you put a Subway in there. Or some. Why? I'll tell you why. Because the person that's going to go and buy the Subway sandwich, the $5 footlong, is not the same customer that's going to buy the Boar's Head meats. So it's really not a competition.
Really?
You ever taste the difference?
Yeah.
I like both.
Subway.
I like both too, but,
Sports head is
okay, but so you see that, so it's
its
just,
own class.
right, well, it's a different customer base. And it's funny you say that because the spotters won't buy from them, but that's a whole other story. Because, a whole other story, even with the roast beef. Anyway, so if you take a look at the due diligence paragraph, coming back to this, you'll see all the different things that it talks about that you're allowed to look at. Not that you're allowed, that you think, just as examples, because in the second line of the paragraph, it says that the buyer has the right to determine whether the property is suitable, these are magic words, in buyer's sole and absolute discretion. And it then goes down to at line 134 where it says, buyer will deliver written notice to seller prior to the expiration of the due diligence period. Again, these are not fuzzy dates. These are strictly construed and they are strictly enforced. You miss it, you blow this notice period, you're buying the property or you're losing your deposit. Prior to the expiration of the due diligence period, a buyer's determination of whether or not the property is acceptable. Well, what does that mean? We've defined what it means earlier on up. It's in the buyer's sole and absolute discretion. You can be on a whim. All you have to do to cancel the contract is to send a letter that says, I have determined that the property is not acceptable. I hereby elect to cancel the contract. When you do such a thing, never, ever, ever waffle on those words. Because what people are tempted to do is say, I will cancel this contract if you don't give me a reduction of the purchase price of $300,000 to compensate me for the faulty widgets. You haven't elected to cancel. And if that letter goes and the time frame passes and all you've said was, I will cancel if you don't, you haven't canceled and you're going to lose your deposit. Clear as, you have to be simple and clear when you do that.
So the buyer has the risk of losing a deposit in certain instances like that. As far as the seller or the buyer messing up and causing the seller maybe time off the market, is there a compensatory?
No.
No.
Not because part of the benefit of the bargain, the meeting of the minds, if you will, is that you've agreed, the seller has agreed to take the property off the market for a limited amount of time to let the buyer do the investigation, because that's what the market requires. Now you'll also notice, I passed right over this because it almost never gets used. There's at line 124 is another checkbox where the buyer can accept the property as is without investigation, and it happens. In a very tight market, you'll find that buyers will actually investigate the property and do all their examination and whatever they can without even signing a contract. And then come to the seller, because they have more bargaining strength in the situation, and they say to the seller, I'll buy the property, I don't need an investigation period, here's a $100,000 deposit, I'll close in 2 weeks. That's the strongest offer you can get. There's no contingencies, it's clear as a bell. They've done all their work, and the seller's going to say yes to that over the guy that says, I need 90 days to sniff around. So you talk about, now, you'll also see in this same paragraph, after the right to cancel, it says that if they don't cancel, then they're accepting the property in their as-is condition. But then beyond that, it goes on to say that the seller is granting to the buyer the right to go on the property and make investigations. Well, when you talk about investigations, you're talking about soil borings, surveys, going and sniffing all over the building and things like that. There's a provision in here that says that the buyer indemnifies the seller, which means protects the seller against any claims for damages or damage to the property, and that the buyer agrees to fix anything that they do. So if they're going to go and drill holes in your parking lot, they're going to fix the holes as a condition. Now, in a more sophisticated contract, when I can get away with it, usually people will agree, I will make these repairs a condition to the release of the deposit. so that before that deposit goes back to the buyer, we need proof that you fixed those holes. And pay for them, by the way. It also provides, speaking of paying for them, the reason you want to pay for them is you want to make sure that someone can't come back and say, hey, I did work on your property, I need to get paid, or I'm filing a lien on your property. Which there's something called a construction lien, which I'll talk about later on in the course, where if you don't pay the person that's doing the work on your property, that person has the right to file a lien, which is kind of like a mortgage, but it's involuntary. A mortgage, you have to sign a piece of paper to get a lien on your property because you're getting the money. But if you take the benefit of someone's services, only certain enumerated persons, that they can put a piece of paper as against your property, and it's a cloud until you pay them. It's a little unfair because real estate agents can put a lien, but lawyers can't. That's unfair. That's an editorial. After the inspection period is done, you head towards closing, but there's one last quasi-inspection. If you look at paragraph C going on to the next page, it's called a walkthrough. Yes?
Then you talk about someone who does repairs on the property and you don't pay them or you don't pay them sufficiently. Maybe that's the same thing. They can put a lien on the property regardless of the extent of the repair. I mean, if they just did something with a few $1,000.
Oh yeah.
For the,
well, sure. I mean, I'm going to, without glossing over the whole construction lien law, assuming that you have a direct contract with the owner of the property, then it's fairly simple. If you are if you're an electrician or a plumber or a carpenter, and you are hired by a general contractor to do work on the property, and yes, it could be and liens are put for small amounts all the time, there's steps that have to be followed.
okay. So if I hire a general contractor, that guy goes out and hires a subcontractor, doesn't pay a subcontractor, that subcontractor has some
rights if he filed it with the proper paperwork. And I don't want to go too far down that road right now because it's very complicated, but I promise we'll do it later on. Yes. The answer is yes, the general answer. Anybody else? Okay, so just before the closing, you get to do a walkthrough. Very common with houses, also necessary with commercial. You get to, it's what it says. It's not a new inspection. It's not the right to raise additional issues or to create additional contingencies. It's simply the right to take a look and make sure that the seller has complied with their obligation, that there's not weeds growing through the parking lot, that there hasn't been damage. In a situation where you have owner occupied, whether it's residential or otherwise, this is really important because, especially in residential, you know what happens when you're moving out of a house? The nice people that you've hired to move your furniture, it's not their house, and they make mistakes. Yeah, and they take that couch and they go bang right into the wall. And so there's a chunk in the wall. That's the seller's problem. The seller's got to go back to the mover, but it's the seller's problem. My favorite of the walkthrough stories, and house stories, I hate residential closings, by the way, because I've done plenty of them. That's where the littlest things cause the biggest aggravation. Commercial, no. Commercial is very professional. There's money involved. There's financial analysis involved. There's zoning. There's land use. Yes, there's some retraining, but it's not like the seller moves out of a house, and back a few years ago, I won't leave the numbers out, there was something called grass cloth wallpaper. Very popular in condos. It was a kind of wallpaper. It looked like straw on the wall a little bit, okay? And it was a natural material. And especially if it was a condo on the beach, the windows are open, it fades, except where the pictures were hanging. So when the seller moves out and you go in to do the walkthrough, there's this beautiful grass cloth wallpaper with dark squares everywhere. And of course that gets into a, hey, it's what it is. Nothing was changed, just the pictures came down. And it always causes a controversy. Or the stain, the pet stain, is in the shag carpet underneath the couch. Of course, they put the couch on top of it when they were showing the house. So that, I mean, most people change their flooring, but not everybody. You know, it could be beautiful carpet throughout the house, except right there under the couch. And you don't want to change the whole house full of carpet. Residential is just lovely. So that's what that's part of what the walkthrough is for. The other nightmare that comes along with that is when you get the call that says, oh, we want to stay an extra 2 weeks after the closing while we fix up, it's called a post-closing occupancy agreement. And it's headaches. I hear the chuckling, it's headaches. You have to make sure that when the seller moves, all of those things are, and you hold money back. It's not easy. Okay. Commercial property, paragraph 8, operation of the property during the contract period. It's a little less easy than it sounds. It's basically you're going to keep running the property the way you have been, but more importantly, you'll see check boxes there, because let's say there's a due diligence period, or let's say it's 6, 8, 10 weeks between the time of the effective date and the time of the closing, and there's empty spaces and the seller wants to lease it up. Well, this provision says no, if the right box is checked, that the seller cannot enter into a new lease for the property without going to the buyer first. And the reason for that is that lease will continue through past the closing, and the buyer is stuck with it, so the buyer needs the right to approve it because maybe the rents are too low, maybe he doesn't like who the tenant is. So that's probably the most important of this little paragraph. Closing procedure, fairly simple. Possession, I've just mentioned possession. Usually it's possession and closing, subject to leases. Closing costs are all enumerated in 9B. There's different costs. So the biggest cost other than title insurance is a transfer tax called the documentary stamp tax. On any deed, it is 70 cents per $100 of consideration. Most people say $7 a 1,000, but it's really computed at the $100 level. But it turns out if you do the math fairly quickly, as soon as you get into larger numbers, it's a lot of money. But it is a seller's expense by statute unless there's a contractual provision that alters it. It's almost never altered unless it's a crazy contract, and it happens. It talks about, so the buyer pays his own attorney, buyer pays recording, anything having to do with financing, seller pays his own attorney, the transfer tax I just talked about, and if there's title defects, it's the seller's expense. And here's where, if you remember, I talked about title defects, and I talked about monetary encumbrances. So here at line 164, it says, if seller is obligated to discharge any encumbrance, mortgage, if you will, mortgage judgment lien, and fails to do so, buyer can use the purchase price proceeds to satisfy the lien. So that's where the obligation is set forth to get rid of those monetary clouds on the title. Documents, fairly easy. There's relatively standard documents. We'll go through types of deeds and what their meanings are later on. Bill of sale is for the personal property. You're buying equipment, the desks, the chairs, a warehouse transaction. Recently I had one, the racks, because even though they can be removed, it's an important feature to be included with the purchase price with the racks, where the buyer can put the merchandise in. It was already there, it didn't have to be moved. Used equipment doesn't have a lot of value, so that's something to consider. That particular one had a forklift as well. It wasn't worth a lot of money, but it's how you get things up on the racks. And you gotta make sure that all the parts of those kinds of things, that was another controversy. The racks were there, but the shelves that were part of the racks had been removed. There was a bankruptcy as part of the sale, which was difficult. Leases, rent roll, tenant and stock letters. So you're buying a shopping center or an office building and it's filled with tenants. So you want to first thing you want to know as part of the documentation from the seller to the buyer is who are the tenants, how much are they paid, how long are the leases, do they have any secret rights? Secret rights? What do secret rights mean? It's a lease. Aha. A right to extend. Now, if you have, obviously you read through all the leases and you'll find this out. Right to extend means that you may see a 3-year lease, but there may be another piece of paper that says that the tenant has the right at their own election to extend the lease for another 3 to 5 years at a low rent. Well, that's gonna cause the value of the property to the buyer to go down because they're expecting new tenants and new rents. More importantly, how about a right of first refusal? This is another situation of going back and forth with on this Burger King lease, is that Burger King asked, or the franchisee asked for a right of first refusal to purchase the property if the seller went to sell it. That would be easy if we were talking about a freestanding property. But when you're talking about an out parcel in a shopping center, where, again, take this room, here's the shopping center, here's the main building, there's the Burger King, okay? What happens if we are going to sell the whole shopping center, which is the normal, subject to all these leases, and this one lease for the one little piece over there has a right of first refusal? Are you giving them the right to buy the whole shopping center, which is unlikely? Or are you giving them the right to buy just their little out parcel, which means you're carving it out of the rest of the shopping center, which has its own complexities? So that's something, so why am I getting off into this tangent? Because on these documents, when you have tenants, you make the seller go, you'll see the reference in here, you make the seller go to each tenant and provide a letter which gets delivered to the buyer, which is called a tenant estoppel letter, which says, I have a lease for 3 years, check mark. I do or do not have a right to renew, check mark. I do or do not have a right to purchase the property. I do not have claims against the landlord. I'm owed free rent, I'm owed tenant improvements. All of these things are statements from the tenant to the buyer stating what the tenant is stating their rights are. Now, unfortunately, I glossed over a legal term, and I apologize for that, because it probably went over some heads and nobody's even paying attention to the word. It's called an estoppel letter. Sounds like a weird word. What does it mean? Estoppel is a legal principle, you know too much. Estoppel is a legal principle that says if you make a statement or engage in an action, you cannot later come back and act differently and change your mind if someone is relying upon your statement or action. So, when the tenant signs that letter and says, no, I don't have any rights to renew the lease, and then once you close on the shopping center, they go, aha, I found my renewal. No, you said you did not have a right to renew, I bought the shopping center relying on it, you are prevented from, or legally stopped from, asserting that right later on, because it is in contravention of what you said in your written statement. Okay? That's what the estoppel letters are. They're used for a variety of things. They're not, besides landlord or tenant, if you go to pay off a loan, it's called a payoff letter, really, in modern parlance, but it's really a letter from the bank that says, for purposes of your closing, if you pay me $976,312, I will satisfy the mortgage. So they can't come back later and say, no, I meant $950, because you closed in reliance on what they said they are stopped.
To your detriment. Relying on information to your detriment.
Correct.
That's the phrasing I heard.
But
Listen, links for stop line, I never heard it in real estate.
has to be written though, right? This is.
Oh yes, absolutely. And that's what this is called for. Now there's other things in here that you'll find that you won't find in residential, and it's usually spelled out a little more, and it's actually pretty good that it's in here, where they're talking about other documents that are required, including a tenant subordination, non-disturbance, and a torment agreement, called in shorthand an SNDA. That is a tri-party agreement, and I don't want to go into it in too much depth now, except to say it's an agreement between property owner, landlord, the property owner who is the landlord, the tenant, and the bank, that says that if the tenant is good and pays their rent, if the bank forecloses and takes the property back, they won't throw the tenant out. Simple enough, but it's a very long, complicated agreement. It's negotiated because everybody wants to put their own special rights in there. Other documents you'll see here that are required as part of the closing. Fairly simple. It's a letter from the seller to the tenants that says, hello tenants, I've sold my property. starting tomorrow, please send your rent and any other notices to Joe Buyer. Easy, but it's necessary because otherwise the buyer goes in there and the tenant says, who are you? I'm dealing with him. So it's a standard closing document. It's called for right here in the closing documents. What happens if the tenant says no? I don't want to sign it. Now, most tenants are violating their lease if they refuse to sign the stop letter. But you want to get to the closing. You don't want to go start litigating with the tenant. So what do you do? Well, this says, if any tenant refuses to execute an estoppel letter, seller will certify the information regarding if the tenant's lease is correct. It's a little bit of a risk from the buyer's standpoint, and again, this is a printed contract, but a more sophisticated contract will say that in a shopping center, a multi-tenant shopping center, we require estoppel letters from any tenant in excess of 5,000 square feet, any tenant that's occupying more than X percentage of the shopping center, national tenants, etc., and the landlord can certify by a separate statement not more than 20% of the leases. Something like that. Some standard where the risk is limited, but you take into account that you're going to have some uncooperative tenants who are being difficult.
So in the case of like anything that's like large commercial, whether it's like, you know, hundreds or thousands of tenants, does it even make sense to try and go get like itemized estoppel letters, or like is it better just to get like the umbrella one from the seller or from the landowner that says, hey, this is, or like do you have to try to go get individual estoppel letters, and only under the assumption that they're not being cooperative do you then go and get kind of like the seller himself to get like an umbrella one?
You really want, well, if it's a very sophisticated seller, like a national, I think I used Kimco as an example, where you have, where they have a good reputation and you know what's going on, you can get a certification from them as to the smaller tenants. You may still want them from the larger. As a general rule, you want them from the tenant because, quite honestly, you don't trust the seller.
Yeah.
You don't trust it. Now, yes, is it cumbersome? Yes. Does it take time? Yes. Is it necessary? Yes. And if the buyer is financing, or if you're refinancing the property, your bank is going to require it. They're going to require their form of tenant estoppel letter with all kinds of statements and certifications that the tenants are going to push back on, and it's a back and forth. And is it easy? No. Is it? But it's required because you won't get your loan otherwise. And the reason for that is the bank, when they're evaluating whether to make that loan on the shopping center, they're looking, yeah, okay, so the landlord is a good guy, and he's got a good credit rating, and he's been paying but if those tenants aren't paying the rent, that shopping center is not going to have the cash flow to pay the mortgage. And so the bank is going to look to the tenants as the source of the ultimate repayment of the current monthly payments. So they want to know the tenants are real. That's why. And they want to make sure if they need to foreclose, they're going to also require the subordination agreement, which is a document that says that the loan comes before the lease, which is standard, but it's a problem. Well, I'll get into that more when we get into leases. Indeed. Then the other documentation in this paragraph deals with resolutions and things and certifications if the seller is an entity, if it's a limited liability company or a corporation or a partnership, you need to know that it exists. You need to know that it's in good standing, and you need to know that the parties who are signing the documents for you have the authority to do so. Where's the problem there? Well, we had a situation where there was a limited liability company who was selling a piece of property. Limited liability company, of course, is an artificial entity, and in addition to what you see in the Secretary of State's office when they file their articles of organization, there's a document called an operating agreement. Sometimes it's called company regulations. That operating agreement is basically a partnership agreement amongst the owners and sets forth who can do what. The officers in a LLC are usually called a manager, although you can call them the same as corporate if you want to by statute. So, person comes to the closing, so I'm the manager of XYZ company, and I have the authority, and I'm going to sign a document that says I have the authority to sell this piece of property to you. Well, when the operating agreement was examined, which is the contract amongst all the parties, the operating agreement said the property could not be sold without the unanimous consent of all the members, which are like shareholders, because it was there for the protection of everybody. The manager couldn't go off and just sell it without everybody's consent. So his false statement, his false resolution was meaningless and did not give him the authority to transfer the property, and therefore the transaction was no good. So you need to look at all the documents related to the entities and make sure to confirm the authority of the person signing the document. Okay. If you recall, when we were going through the purchase price, we talked about very briefly adjustments to the purchase price. So there's taxes and prorations. And you start looking at D, especially with income property, there's rent coming in and there's expenses going out. And those things have to be adjusted, because if you are operating the property and the buyer's going to come in and operate starting on Monday, they were closing on Friday, they're going to come in on Monday and start operating the property, you need to be able to adjust so that the rents for the days in between get adjusted. I was going to ask a question, I'm getting an obvious answer. I'm wondering, should we take a break at the halfway point? Yes? I have no problem with that. We can go bathroom, get something to drink, but not too long. I mean, it's a long course, and I understand that that's unnecessary.
Is that right now, the break?
Yeah, sure.
Not for you, Ryan.
Makes sense.
I didn't get that.
I don't know what I'm talking about.
What is it not as bad as it was this morning?
I think everybody stops like,
I can't wait until the class actually starts. Huh? The class is teaching you about the law. It's going to cover you in there and stuff for you to cover your ass when you do a contract. That's what I want to state. Just like you're looking at. Yeah, but I mean, like maybe it wasn't necessary. Very similar. Honestly, when you're in commercial market, hardly ever do I ever do it. He did a good job. On the roll. Probably because I registered, then I registered. Oh, okay. Yeah, because it's good. It was going to be. I wasn't married when she was at the time, you know. I feel like. Yeah. What do you mean?
How do I get out of here?
I don't know, I think I'll be able to.
So you did well in the
It is. I know how, but I'll get the door. I used your easement. For which I thank you. It's very convenient.
Boy. I'm there with it.
Did you study it for the test?
By the way, those questions belong in the development class.
Is it?
I think so.
Okay.
I mean, I can answer one.
Well, yeah, I registered.
You got me a football game this weekend?
This class.
Oh,
See, so we got a Chiefs game right now.
but all right.
Yeah, well, I know this is
I want to
So
see
I
that.
thought
Yeah,
last period at least, you know, one class related
You
to
gotta
the
do a real
other.
test.
Yeah, class is related to, one this is one thing, the other one is another thing, and then one online is another thing. And then
We
software,
actually go with the cold
supposed to
the
install
Texas,
software,
Texas.
to make it.
Those are
I don't have
Yeah.
a software Argus. Yeah.
Well,
kind of take it overnight right now, and they're gonna go to Kansas City.
To get it. I think it's a big one.
Kansas City,
But up here, you know, last time I said to choose, that's what you have to do everything. So then I decided to make it.
They had
The other
you-
one was just so.
Yeah.
You know, like, I was, I never knew exactly exactly, you know, what you want. Sometimes you're not like,
Playing as big as they were earlier.
like, for me, it's especially when class one. Like you. Go over what's giving class and then it's middle, and then not like other exercises. So, did he explain what the evaluation is?
Like we.
Just in the class.
I had him on a draft.
At the beginning or not?
No, I didn't have it. It was a.
I understand this. Oh, I did.
I did not have it. Like, you talked. I had him too. I had him too. He's great, man. He did not. He got everything that we got placed there for no wonder. He plays every play. It never comes out.
You bought it already?
Yeah.
I bought it, but I saw they had it also in, so I downloaded like a file. Oh, and then I saw that we were supposed to buy it. Yeah, and then I bought it. They gave you a box with a little access code. But, did you install it already? It's already, does it work only online, or can you download it?
He's been around a while. I don't know if it was a Patriots or not, where he won that 1 year he was injured. Yeah.
Oh, really?
You can't download the book. Because you can buy it.
Yeah, it's different. You bring to the
You watched the next one? Did you
Oh, really?
start off again?
This is your buy.
We were talking about that.
You buy it? I have it, you know, this one. Sorry. You buy it, I think you still
Well,
have
he had one saved. And no, in the end, it was Georgia, was rated higher than that. First on field pressure.
It is feature bed. Yeah. Once the thing expires, you don't have access.
So when you hear it, what they did was they had this competition. High school.
Yeah.
It looks different, man.
Were you in the morning class?
It's like how to rank. I think he was first on the game. Yeah. Okay, so what they did was, after Fields beat him up, he said, okay, he's the number one pocket passer. He's the number one all-purpose. Coach Red. Yeah. Fields was all quarterback was over him at the end. But they split him up, so he's the number one dual.
And it costs the same, but in Amazon. So in Amazon you have both of these, right? Here you have it costs the same.
But the reason he gets sacked,
I'm not sure it's
almost
the
most
same.
of all of
It's the
them.
same. It's also the same edition, I think they.
It's like, that's true.
But it's the same thing, you know, it's like what's the next one?
That's why I think
No, the client. No, I mean, the class, I thought they think about it.
No such thing. Oh, yeah, there's no such thing as stand.
Yes.
That's what I I thought you had been before yesterday. They said 13. From the second part of today we have a full day, and then the next Sunday is a full day. If they take over one subject, then I could take I know I mean, I didn't know that before,
That's very abstract. It's not like a I'm just saying, when in Rome, not doing that. I don't know, so like as of right now, yes, it can make a break. You're like, okay, and we're not sounding like he's like, oh, you're supposed to like shit around the house, just like whatever. But like maybe you could do like 2 hours. Get started to get things abstract. I'm not like I would say
Like a minute.
Okay, so make sure. Okay, that's 20. Let's go back. I want to regress a second and answer a couple of private questions publicly, just because I think they're good questions and it's good to talk about. Question came up, what happens if you're buying a piece of property from a friend? Do you need to spend the money on the title search and the title insurance?
Yes.
Ooh, listen to the tide, I like that. Tell me why.
Because it has nothing to do with the friendship. It's that, first of all, it's business, so business is business.
That is a perfect answer.
So-
It really is.
I do want to be a lawyer, but business is
Building next door.
business. Yeah. But besides that, they might not know something is actually wrong, and maybe they didn't get the search done correctly. And so that's why I would do it regardless of the friendship.
Excellent answer. And it's a very valid answer, and it's for real, because to be your best friend has no idea what's going on with the title to their property. None whatsoever. So the only way to make sure and to stay friends is to have a title search. As a matter of fact, as recently as yesterday, I had an email from somebody in my estate planning department. 3 brothers inherited property from their parents. The last parent just passed away. And they made an arrangement where one brother's going to take the property and give money to the other 2 brothers. The brother that's taking the property, family property, wants to have a full title search done and pay for title insurance. Why? You might say, why? It was mom and dad's house or whatever. Because he's paid the money, a lot of money, and doesn't know. Nobody really knows what the status of this title is. And to be safe, you spend a few hundred or a few $1,000s because you're making a much bigger investment than that. So the correct answer is friendship. Friendship is one thing, but this is business and it's a lot of money. I'm going to address your question too. We were talking about it was a specific contract issue dealing with a special clause, and the primary purpose of this printed form is so that real estate agents can fill in the blanks and present an offer. Because, like I said, if it's going to be a more sophisticated transaction, I'm going to use a custom typed form that covers more detail in areas that are important to people. However, in some situations, and I mean, I've closed up to a $10 million deal using this kind of a form because the parties they see that it's not been tinkered with. They know it's standard. I hate that phrase when you deal with the contract, but it's a form that people are familiar with. They know what it says, and they're willing to deal with it. So the add-on that we were just talking about during the break was a provision that said that the buyer was asking the seller to provide a lien search, including that there were no code violations and that all building permits would be closed. So, lien search is easy. Technically, it is part of the title search. A buyer would normally order a lien search, but they may or may not order code violations, more so commercial than residential, but it's either way, and open permits. What happens, and this is commercial or residential, what happens is someone goes to fix something, or to improve something, or to build the space out for the tenant, and they go to the municipality, the county or city, and obtain a building permit. And they get the building permit, and they hire the contractor, and they do the work, and maybe they get the one inspection that's necessary to get the authority to do the next. So let's say they get electrical, and they get plumbing, and then they get in a hurry, and they put up the drywall, and they paint, and they move the tenant in, and nobody ever bothers to get the final inspection. If you don't call for the final inspection, the building permit stays open. And now you go down the road, and you go to sell the property, and the buyer does an investigation and sees that the building permit is open, if they're smart enough to do the investigation. Well, unless you have a special clause that specifically says, which I think the new residential contracts do say, or can address it to some extent, that the seller's going to take care of these permit issues, they're not taken care of, and then it becomes a problem down the road for the buyer. Because what happens, and I've seen this countless times, 3, 4, 5 years later, the buyer goes to have something else done. They go to get a permit, and they bring the building inspector in, and the building inspector sees that you replaced the valve in the shower and never had it inspected. Well, that's plumbing. Plumbing has to be inspected and signed off on. I've seen in a condo transaction that they actually made the buyer tear open the wall of the shower, which means remove the tile, which you can't replace with the same stuff, open it up and let the inspector inspect the valve installation. In order to get the permit closed, it was the only way to do it without getting a violation. So, in the particular clause where it was required that the seller close any open permits, that's the time to do it, because if the seller did the work, hopefully the seller did the work. These things don't leave the records. So if the house has changed hands, or the property has changed hands 3 or 4 times over 10 years, and it was the guy 10 or 15 years ago that did the work and didn't close the permit, it's still out there on the records of the municipality. I've actually served recently on a Florida Bar task force on this very question, on the open permits, because it's a problem in closings. We're trying to get a law passed that after a certain number of years, you don't have to deal with it anymore. 1, 2, that the buyer, a later owner, can hire a contractor to fix whatever the problem is without the contractor having any liability for what the contractor 10 years ago didn't do. Because you start to get into all these building issues. So it's a variation usually, and I would get to it in special clauses, typewritten added clauses to these contracts cause nothing but trouble. Okay, so I started to talk about taxes and prorations. Real estate taxes are paid annually in the state of Florida in arrears, which means now it's early in the year, but if you were closing on a piece of property on February 1st, it's the seller's obligation to pay the taxes for the first month of the year, but the bill doesn't come out until November. So you adjust it based upon an estimate on the closing statement between buyer and seller. Buyer gets a credit, then buyer pays the whole tax bill. Then there's a whole discussion in here about what happens if the bill varies. Rarely do you get the demands made unless it's a lot of money, but you can go back to the seller and say, hey, we adjusted it based on a tax bill of $3,000. It turned out they raised the taxes. It was a $4,000 bill. I want the adjustment corrected. That's fine. It's not very much if it's a $3,000 or $4,000 bill. When you start adding zeros, it gets to be more of a conversation. Okay. Another quirk, it's funny because as I look at this, and I work with this contract all the time, as I look at the words to discuss it with you, I see these little parentheticals, and there's so much in 3 words. And these little parentheticals have such an implication that it's amusing me. So if you look here at the prorations, it says rents, I'm on line 181, rents, parent, based on actual collected rents, I lied, it's 4 words, not 3, 5. Based on actual collected rents. So here we are, it's the 12th of the month, right? Cheating? Yes, 12th. And we're going to have a closing on Monday. We're buying a multi-tenant facility. The rents that were collected on the first of the month are in the seller's pocket. So the buyer wants the second half of the month rents credited on the closing statement. It's proper, because if he's entitled to, he's gonna be the owner. But 3 tenants haven't paid their rent. They're a little late. They're okay, the seller's been okay with them. Yeah, they pay a little, they usually pay by the 3rd week of the month, and they're kinda okay. What happens? Should the buyer get a credit for money the seller hasn't gotten yet? Is the seller supposed to give up that money, even though he hasn't collected it? This little parenthetical says that prorations are only based on actually collected rents. These 5 words turn into a paragraph like this in most typical custom contracts, because you get into a whole litany of conversation about, does the seller have an effort to go after the tenant on behalf of the buyer to collect that rent, and then it gets divided. What happens after closing when the check comes in? What happens if the February 1st rent check comes in, that's the buyer's money, but the tenant kind of forgot the January rent because he knew there was a closing going on? Does the buyer have an obligation to go and collect that money and chase after the money? Does the seller have to cooperate with the buyer? There's all these litanies, which here is glossed over in 5 words. So you can see it can just keep going on and on. Insurance, well, that doesn't happen anymore because insurance is almost never assumable. Operating expenses prorated the day before closing. The day of closing belongs to the buyer. That's important. When you're doing prorations, the day of, it doesn't matter if the closing's at 5 o'clock, the day of closing always belongs to the buyer, unless the contract says something else. Talked about reproration. Liens. So the special assessment liens in the next section, it's a title issue. It's usually like for roads and sewers, things like that. And there's 2 kinds of liens. There's a certified lien where it's already been passed, or there's a pending lien where they're thinking about it. And then there's also, it depends on, has the improvement been done? Who's getting the benefit of it? Has the seller gotten the benefit of the improvement? And this is all negotiable as to who's going to pay what part of it. Or are they going to start assessing this lien to do things in the future that will only benefit the buyer, in which case why should the seller pay for it? FERPTA. FERPTA is a biggie, and I'm just going to gloss over it now. We'll address it in great detail when we get to more stuff like that. The Foreign Investment in Real Property Tax Act. So what was going on in the United States was that people would come from Europe, South America, wherever, and they would invest money in a piece of real estate in the United States. And they would make a lot of money, a big profit. And they would sell it, and take the money, and leave with their money. And even though technically it was a profit made in the US and subject to US income tax, they never paid it, and there was no way to enforce it. So the government passed, the federal tax code was changed to end this section, and it says that if you are a non-US taxpayer, it's now been increased, it used to be 10%, now it's 15% of the gross proceeds of the transaction are to be withheld from the seller and remitted as a withholding to the IRS, except if the seller proves that they are not a foreign person, that they are a US taxpayer, or they have an exemption letter from the IRS because they have a loss, or there's one other minor residential exception as well. If it's a small piece of property that's going to be used by the buyer, under $300,000 to be used by the buyer as a residence. So what happens is for most transactions, although in South Florida we do have a lot of foreign sellers, but for most transactions all you have to do is put your residence address and your taxpayer identification number, and you're exempt and there's no withholding. There's always the issue at a closing, because you're always going to get somebody who's a little bit paranoid. Can't I just put the last 4 numbers and show you and then not put it in the form? No. The federal tax regulations require your entire taxpayer identification number on a FERPTA affidavit. People are afraid to put their whole social security number down, but it's what the law is. Okay. Someone asked me earlier on what the definition of an escrow agent was. And when I do a residential mortgage closing, my line to people is, every time somebody asks a question in a residential mortgage closing, they create another form. That's why if you ever bought a house, you get a stack like this of pieces of paper. There's really 3 pieces of paper that mean something. There's the note, the mortgage, and the closing statement. Everything else is nonsense. And it's getting worse because they took a closing statement that was very simple and they created a monster called a closing disclosure that goes on for 6 or 8 pages that is incomprehensible, but it's better for you. That's what they say. So, escrow agent. Here they not only define the escrow agent, the who is the escrow agent was defined way back on the first page. So now here it talks about the escrow agent's duties. Whatever money gets given to the escrow agent, and really what this is more than anything else, is all the disclaimers. That most of this paragraph is to protect the escrow agent. And it says that once we give you the money, as long as you do what's under the contract, then you're not going to be responsible. If there's a dispute, you can continue to hold it until the dispute is resolved. If there's a dispute, you can put it into the court registry and you're out of the whole controversy. There's also special language for the real estate brokers as to what they can do under Florida Statute 475 because that's who authors this contract. What it doesn't say, which what I would have in a custom contract, is if my law firm or if the other party's law firm usually is holding the escrow money, we would put in a provision that says, notwithstanding that we are the escrow agent, we can continue to represent our client in the controversy. Because what's going to happen, nobody's going to release the money without a resolution to the dispute, whether it's mediation or it goes to court, whatever. And truthfully, most sophisticated people don't want the money into the court registry. They're going to work it out one way or another, even if they fight over it. This will let the lawyers continue to hold it. This paragraph 11 is basically, oops, I didn't do this right clause. It says, before I can default you and take your deposit, I have to give you notice that you did something wrong and you get 5 days to fix it. It's, except for closing. You can see the very last sentence is except for closing. And really it's to prevent a technical default from causing you to lose your deposit and causing all kinds of bad and nasty things to happen. Force majeure. That's fancy words now. Now this is fancy legal words. Force majeure is fire, storm, or shipwreck. If something, that's a catch-all. If something happens that is beyond your control, and it's pretty much defined, that causes you not to be able to perform and it's not your fault. And I said, and it's defined. Hurricanes, floods, extreme weather, earthquakes, fire, or other acts of God, unusual transportation delays, wars, insurrections, acts of terrorism, blah, 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 which causes the non-performing party to not be able to perform, then you cannot be held in default as long as soon as the event goes away, you get back to performing. It sounds like a lot, but it's, think about hurricanes and what happens here. This doesn't have, I don't believe, what's in the residential contract that says if you may or may not know, if there's a hurricane in the area, which is referred to in the industry as being inside the box, which is a map, they will not write insurance for you to acquire a piece of property. And it's usually houses where this comes up, where you're ready to close, everything's fine. The hurricane's in the Bahamas, it's beautiful out, but it's in the box, and the insurance company's afraid it's going to turn, and they suspend all underwriting. So the residential contract has a provision that says that if that happens, there's a pause until underwriting is resumed. It's fair. I mean, if you think about it, it's not your fault. Same thing with this. This paragraph covers it basically, I can't do it, but it's not my fault. 13 is fairly basic. Return of the deposit. If you're entitled to get your money back, you get it back. And that's basically what that says. Okay. 14, defaults. This is also a very important provision that is used, pointed to, and sometimes it's doctored and shouldn't be. So, the first paragraph A is what happens if the seller defaults. The seller's default is unlikely. Obviously, they want to make a deal. Can you think of a situation why the seller might deliberately want to default on the contract?
Better offer.
Change your mind.
Yeah.
better offer. So, what happens is, in addition, so the buyer then, with the seller defaults, has a couple of rights. One right is to say, okay, I want my money back. But remember, that buyer's been investing money on the due diligence, he's made loan applications, he's paid fees to people, it's costing him money, and besides, he really wants that property. And he agreed to that property. Well, it's a principle that no two pieces of real estate are the same. Real estate is unique. It's not like if you enter into a contract to buy a blue Toyota, that you can't find another blue Toyota with the same equipment on it. But if it's a building, or a house, or a field, or whatever it is, there's only one in that location with those characteristics. So the law grants, if it's in the contract, which it is, grants to the buyer the right to specific performance. Specific performance is a legal remedy which the buyer has when they file a lawsuit against the seller, just like it says, to make them specifically perform the contract they agreed to perform. You have to do what you said. Now, they also have in here a provision that says the buyer can elect to receive a return of their deposit without thereby waiving any action for damages resulting from seller's breach, and can recover the damages. This is a situation where we do play with this contract, or we will alter many contracts, but what it basically says is, if you don't want to go through the specific performance, and you spent $50,000 to investigate the property, to do your searches, to pay for inspections, now you're going to sue the seller for that $50,000. Most custom contracts will either remove that and say, no, either take your deposit back and go away mad, or sue me for specific performance. Or we will put a limitation on damages and say, yes, you can recover from us up to $25,000. And that's reasonable because the seller says, look, I don't want to fight about this at all. And they'll if it's big enough, they'll write a check, especially in a situation where it's the better offer. But that's unusual because if it's the better offer, the buyer's going to want that property. And then it says, the last sentence, and this is another one that gets altered by us, not by the agents that are using the brokers. If the buyer elects a deposit refund, so the seller is now defaulted, and the buyer has chosen the remedy of taking their deposit and going away because they don't want to fight about it, seller may be liable to broker for the full amount of the brokerage fee. So now, if the seller doesn't fight, here it says that, okay, the broker did what he was supposed to do. Now the seller is defaulting, and he's letting the buyer take his money back. Pay me, I did my job. So now you can get hurt for, 3, 4, 5, 6, 7% of the purchase price. The next,
Even if the property never sold.
Well, under the circumstances that are in here. Now, funny you say that. Not funny. Good that you said that. If I'm writing a custom contract and I'm representing the seller, the magic words I have in the brokerage commission paragraph are, the commission will be payable as if and when the transaction closes. So that I'm making a condition. You have to have a closing for any money to get paid. And you're going to see in the next paragraph where it's the buyer that's defaulting, where the buyer puts up a deposit, and I'm going to show you some more magic words in here that have been around for quite some time, that weren't always there. So we talked about the deposit and what the deposit is used for. When you go to the additional deposit after the inspection period, so that the deposit now becomes non-refundable not during the due diligence because you can always cancel. So in the event the sale is not closed to the default on the part of the buyer, the seller may either retain all deposits paid or agreed to be paid. Which means if the buyer doesn't perform, it lets the due diligence period expire, fails to put up the second deposit, but is obligated to, the seller then has the right to go after not only the initial deposit, but the initial plus the additional, because that's what was agreed to be paid. and it's called liquidated damages. You go to court and you allege that somebody has wronged you. You've been damaged. You're not getting the benefit of your bargain, you're losing your profit, you're losing the value of the property. Liquidated damages is an agreed amount that says, we can't really determine how much you've been wronged. So we're going to say that the amount of the deposit in this case is an agreed upon amount of damages, an agreed upon liquidated damages. Now, the next sentence here is one that I usually take a little bit of objection to, and that gives the seller the right to seek specific performance against the buyer. Which means, and it's, I've only seen it granted once, and it was because it was the buyer defended. Which means that if it were granted, the seller can force the buyer to buy the property, which is difficult if the buyer doesn't have the money, if that's the reason he defaulted. Now, all of these clauses, these provisions regarding damages and specific performance and things are why it's so important. Remember the first thing I talked about is the parties? So if you need to know who your buyer is, who your seller is, to know are they recoverable if you have to use any of these bad clauses in the default provisions. Because if the buyer is a newly formed company that has no assets, and they don't put the deposit up and you want to sue them, you're going to get nothing. There's also a good protection provision in here that says if the buyer fails to place the deposit initially, then the seller can terminate the contract and just go away. Because what happens, unfortunately, is that the buyer will sign the offer, the seller will accept it, the buyer will never put the money up. And you're in limbo. You're in complete limbo because you have a signed contract but no consideration.
So is the contract valid without consideration?
No. Well, what is consideration? It may not be cash, but it may be mutual promises that are legal consideration. You don't have to have a deposit.
On a timeline though, right? So it's like, you have to have the money by a certain.
That's performance. But if I promise you something and you promise me something, that's value being exchanged back and forth without cash money. That's legal consideration. Attorney's fees, loser pays the winner, that's an easy one. But again, it sounds like an easy one, but it's an important thing to think about to strike strategically. Let's go back to my example where you have a newly formed buyer with nothing, a new entity. XYZ Corporation was just formed last week. The deposit is small, it's up, and they default, and now you're going to go to court for one reason or another. The entity has nothing. The seller, on the other hand, owns a piece of property. And so the seller is at risk because if the buyer sues the seller and gets attorney's fees, they can get a judgment and execute on the property, or put a lien on the property. So, strategically sometimes, the seller may say, hey, they got nothing. I'm striking this. I don't want this attorney's fees provision. It also keeps people from filing suits because they don't want to pay their own lawyers if they think they're going to win. Notices, it sounds easier than it is. Used to be, have to have a letter. It has to be certified mail, return receipt requested. Then they started to say, okay, FedEx or other overnight UPS, other overnight couriers. The problem is when you deal with things like email notice, federal and fax notice. Anybody use a fax anymore? Unless you're the medical, doctors won't use it. IRS won't take an email. You have to fax the IRS, and it goes. It's true. You have no proof of delivery. So a more sophisticated contract will say you can provide an email notice as long as it's followed up by one of the others, which is great because then what winds up happening is you get your email, and everybody gets emails and reads their emails, and it's a letter. And 2 days later, the FedEx arrives with the same letter in there. It's like, why? But you need the proof. You need the proof that it's gotten somewhere. Needless to say, we're getting into some of the less fun parts of the contract, but, you know. Okay, disclosures. Remember I made a comment that the real estate brokers have an advantage over the lawyers because They have lien rights in a commercial contract where if the commission is not paid as it's supposed to, they can actually file a lien, and it's being disclosed here. I just want to point your attention to this paragraph on 260 on radon gas. This is a statutory required disclosure in Florida on all contracts and leases dealing with real property. Down here in the south part of the state, I don't think you see radon. I've never heard of a reported case of finding radon. It's a gas, particularly up north, that lurks under the ground somewhere. But apparently, maybe up in the north part of the state, it's happened. And it's a disclosure that says radon exists, and you should consult your local health department. But it must be in every contract that's a required disclosure. Risk of loss. Okay, so we signed the contract, and it's October, and the hurricane comes through. What happens? What happens when the building blows down between contract and closing? This talks about what happens. Same thing with unlikely, but same thing with eminent domain. The risk of loss stays with the seller until the closing. So then what happens is you have two choices. The buyer can cancel if there's a damage, it's bad enough. And when we get into the leases, the issues of damage and destruction are much lengthier. Because remember, with a contract for purchase and sale, you're dealing with a relatively short amount of time between contract and closing. With leases, you're dealing with 10 years, 20 years. So you have situations with who's going to carry the insurance, who's going to rebuild, do things like that. Here it's fairly simple. If the hurricane knocks the building down or damages the building, the buyer has a choice of terminating the contract or moving forward and taking the insurance proceeds and dealing with it. Sometimes, again, you can get more sophisticated if the improvement warrants it, not the deal warrants it. Assignability. It sounds like a simple, unimportant thing, but if you go back to your financing contingency provision, if we have a contract that has a provision where I've come to you with that pre-approval letter, and my bank says that I qualify for the $700,000 loan, and I decide I'm going to assign my contract to somebody else, I'm going to flip it. Flipping it means during the course of the contract, you are selling the contract to somebody else. That person may not qualify for the mortgage. And while you may get into an issue with the validity of the contingency under the assignment, if that assignment is not restricted, that new buyer may not qualify for the mortgage, and the whole contingency can be defeated, and the money's got to go back to the buyer. So you have a very unhappy seller. So you want to restrict it. What you want to allow, which the contract provides for, is if I buy an XYZ Corp, because that's the company that I have existing at the time of the closing, and at the time we get to the closing, I want to form a new entity to take title because somebody told me that I should have each one of my properties in a different company. So I form a new company just for the closing. That kind of an assignment is permitted. Any other kind of an assignment requires the consent of the seller. And then the other question would be, would the assigning party, the party who's the original contracting party, be released from obligations? And typically the answer is no. I'm not going to discuss miscellaneous. Real estate brokers. Obviously, you want to know who your real estate brokers are as the seller. You want to make sure that there's statements from the buyers to who they've dealt with. Usually it's a buyer's broker and a seller's broker. You want to make sure that that there's nobody hiding in the woodwork who's going to come out and claim a commission. And again, this does not necessarily have the protections of the parties as much. Honestly, if you read the provisions, the protection of the brokers themselves, because it's a broker drafted contract. But you want representations in a typical contract or in a lease where each party says, I've only dealt with this person, he's my broker, I've only dealt with this person, he's my broker, and we each represent and warrant to the other that there are no other real estate brokers involved in the transaction. And if I'm lying, I'm going to be responsible to the other party if a claim for commission is made by someone who I haven't disclosed. It's for the protection, you can't hide things. Optional clauses. Okay, so you see in the optional clauses, and I don't have all these riders to show because, no, just look at the little check boxes here in line 313, paragraph 22. I didn't print out all these optional riders because there's so many of them, they have so many different things. So, these are riders that are created for special situations because, again, the whole purpose of this kind of a form is to allow a real estate agent to help make the deal by filling in the blanks. A real estate agent or broker is not legally allowed to draft contracts. They are, because that would be the unauthorized practice of law, which is some kind of a crime. I think it's probably.
Sounds like a felony.
Does it?
It sounds like.
It sounds like a felony. Let's go with felony for now. Everybody can look that up. But it's not nice. It's really bad. They come after you and they throw you in unauthorized practice of law jail, and it's very bad. Basically, the idea is to protect the public from people that don't have the license to do things. Well, unfortunately, what happens is that trying to be helpful, agents will take the most dangerous part of this contract, the most horrific part of this contract, which is Article 23, because all there is blank lines, okay? And they'll write things. So the problem with them writing things, I apologize to anybody here who's a real estate agent, I'm not trying to disparage anybody, but like that farmer's insurance company, we've seen it all. They will write clauses that either inadvertently alter what's in the main part of the form and cause a conflict with it. They will write a contingency that has no defined terms, that doesn't, they try to be helpful. And I'm going to give you the very best example of that I can think of is a situation, sometimes you have to go to the residential side of it, where it's subject to the buyer selling their house. And what you'll get is you'll get a contract that says, this contract is contingent upon the buyer selling the house at 123 Main Street. Period. Well, you know what the intention is, right? The intention is most of us can't afford to own two houses. And I really want this new house. It's really nice. But I gotta sell that house first before I can close. So I'm just gonna put this contingency in here, and that's all it says. It's a disaster. Why? Go through what that contingency is. One, when? When do they have to sell it? Because we have a contract here that says you have to close within 45 days after the effective date. How long do they have? Because I gotta move out. I'm the seller, I gotta move out. And if I don't know that you have your house sold, how do we know we're gonna have a closing? What does sell mean? Does it mean enter into a contract? Or does it mean have a closing on the other house? What happens if that closing gets delayed because of a revision in that contract? Is there a contract? I forgot, did I mention that? By the way, do you have a contract on that other house yet? Is it subject to a financing contingency? Does it have an inspection period in it? What's in that other contract that's making this contract float? Well, none of those answers are in this broker drafted contingency. However, there is an answer. There is an answer, and the answer is that in the residential contract, they've come up with riders. And by the way, I kind of glossed over it, but all of these check boxes in paragraph 22 are riders, addenda, if you will, that are attached to the contract that cover different circumstances, different situations. And there is a rider to the residential contract that you can use that has that contingency specifically laid out and provides for contingencies on the sale of the property, contingencies on you know, is there a contract, isn't there a contract, timeframe, start, inspections, all kinds of things that protect the parties a little bit more. But writing something like that in here as a special clause, it's non-specific, and that's where the problem comes up. More riders. I'm looking at the language of these riders, and I'm translating them. Thank God there's the riders, because the contingencies were so vague. Because you'd say, it's presented, and I'm in a hurry because, you know, transactions like this happen very quickly. So you write in, this contract is contingent upon buyer's attorney's approval. When? What does he have to approve? I go to my, buyer comes to his attorney and says, I don't like this deal I made. All right, I'm gonna write a letter to approve it. Well, does he have a right to disapprove the business terms? Does he have a right to approve the legal terms? Does he have the right to approve the fact that it's a pre-printed, established, fully accepted form? I mean, so there's a rider that I think is a little bit clearer. Oh, by the way, how long does he have to approve or disapprove it? The sentence didn't say so. I actually published an article early on in my career for the Florida Realtors magazine called How to Destroy a Real Estate Contract, talking about these contingencies, because quite honestly, when you do something like that, you're leaving it terribly vague with no idea what's going to happen. It's a seller's financing contingency rider that's mentioned. Again, I don't have the riders, but it basically lays out, and there's in residential, there's new lending restrictions. I'll get into it more when we talk about mortgages, but it's so simple. You can't, an individual cannot make a private mortgage loan without going through a mortgage broker nowadays on residential, or a certain licensed mortgage professional